30-го перед Москву поеду, да, я согласен.
Алмата, еще раз здравствуйте. Проверка связи перед началом.
Слышу хорошо вас.
Все принято, спасибо.
может быть, нет, я.
Morning, everyone. Can you hear me? Okay. Nice to meet you.
Құрметті форумға қатысушылар, ханымдар мен мырзалар.
Good day, dear ladies and gentlemen. Let me welcome you on behalf of the Constitutional Board and wish you fruitful during this forum. And please let me we are here with you on the eve of the Constitution Day of the Republic of Kazakhstan. I congratulate you all to this national day and wish you every success. This year, our traditional meeting is dedicated to the development of institutional control in the conditions of transformation of the society and state. In this connection, this meeting is connected with the evolution of constitutional control in the context of transformation of the society and state. And our round table is devoted to this topic. As you know, the President of the Republic of Kazakhstan, in his address to the nation, Kazakhstan has mentioned important steps in the political and legal of our country. On the 5th of June of this year, for the first time, a national referendum was held in Kazakhstan within the framework of which amendments to the Constitution of the Republic were adopted. They commemorated the start of transformation in all institutions. Amendments to the basic law provide for effective measures to further modernize the presidential form of government, strengthen of the role for parliament and local representative bodies, improve electoral legislation, electoral and party systems, as well as administrative territorial structure and others. The constitutional reform contributes to strengthening the mechanism of protecting the fundamental rights of citizens. In this direction, a major innovation is the transformation of the Constitutional Council into the Constitutional Court, with the exception of the list of judges. It additionally includes the Prosecutor General and the Commissioner for Human Rights. The Constitutional Court will consider citizens' appeals to check for compliance with the Constitution of normative legal acts that directly affect their rights and freedoms. At present, a draft constitutional law has been developed on the Constitutional Court of the Republic of Kazakhstan. We would like to change experience and discuss the legal basis for the activities of the Constitutional Court. I express my vision on some issues in my article, which published today in the newspapers Yegemen Kazakhstan and Kazakhstanskaya Pravda. Your opinions and views are of great interest to us and will be taken into account in further work. As the meetings of the working groups showed, such issues as the types of constitutional court, their states, principles of activity, qualification of judges, and the mechanisms for their selection and appointment are of interest for discussion. They also include issues of execution of decisions of the Constitutional Court, immunity of judges, social guarantees. Particular attention should be paid to the model of constitutional complaint, issues of social treaties, and the internal structure of the court. This, of course, is not an exhaustive list, and you can touch upon other aspects of the work of constitutional justice, but this event is held within the framework of the joint program of strategic partner of Kazakhstan, the European Union, the Council of Europe, and the role of the Central Asia for 2020-2023. The forum is organized by the Constitution together with the First Commission of the Council of Europe, the leading universities of the country, the University of Narcos and the University of State Legal University, named after the table is held in parallel in a hybrid mode on the basis of the mentioned universities in the capital and Almaty. Our event is attended by the chairman of the Constitutional Courts of Kyrgyzstan, Tajikistan, and Uzbekistan, foreign experts representing the structure of the UN, the European Union, the OSCE, the Mission German Foundation for International Legal Cooperation, and other international organizations. Our deputies of Parliament, judges of the Supreme Court, senior officials of the administration, justice, law enforcement, human rights institutions, and the scientific community of Kazakhstan. I am sure that the meeting will allow us to exchange views and work out the best ways to resolve the existing issues. Let me declare our roundtable open and move on to words of welcome. Dear participants of the conference, as I have already said, this event has made possible thanks to the support of the Commission. Vladimir Vardanyan will speak on behalf of the Commission. He is chairman of the Standing Committee on Legal Affairs of the National Assembly of the Republic of Armenia, member of the Venice Commission. Please, the word is yours, Mr. Vladimir Vardanyan.
Constitutional Council of the Republic of Kazakhstan, honorable representatives of the state authorities, excellencies, dear colleagues, ladies and gentlemen. Let me, on behalf of the Venice Commission of the Council of Europe, congratulate all of you on the eve of the occasion of the Constitution Day of the Republic of Kazakhstan. The Constitution is the DNA of each and every rule of law state, a pillar for the establishment of a pluralistic democratic political system and environment where human rights and fundamental freedoms are guaranteed. The Constitution is not a rigid phenomenon. It is beautiful in its implementation and motion. Constitutional settings should correspond to the wants and dreams of a particular, constantly evolving democratic society. The very transformation of society, development of national institutions, formation of the democratic pluralistic political system leads to the necessary changes in constitutional settings. From this perspective, it's worth noting that constitutional reform undertaken by the Republic of Kazakhstan in March 2017 changed the distribution of powers between the President and other branches of the state power. The role of Parliament was increased. Some of the powers previously in the hands of the President were distributed between the government and the Parliament. The Constitutional Council received additional competencies to examine draft constitutional amendments and questions to be submitted to a referendum, which was done by the Venice Commission. Since its establishment in 1919, the Venice Commission was cooperating with the constitutional courts as essential in promoting constitutionalism and understood as the idea that all action by the state should be defined in limits set by the Constitution. One of the main direction of operation between the Commission and the organs of the constitutional review is organizing conferences and other fora. Since 1996, relevant conferences and seminars have been held in different countries members of the Venice Commission. This international roundtable is also a part of these activities, evidencing the high level of cooperation between the Venice Commission and Kazakh authorities. I'm sure that such a high level is on the table contribute to the establishment of a direct dialogue between members and the staff of the Constitutional Council of Kazakhstan and relevant national and international stakeholders. And the exchange of views during this event would lead to the cross-fertilization of ideas and experiences between constitutional courts and equivalent institutions. Ladies and gentlemen, different countries in transition have adopted various models of constitutional review, trying to find the best applicable way of safeguarding constitutional values and the rule of law. The majority of countries have established specialized institutions for constitutional review, mostly constitutional courts. Nevertheless, some others prefer to exercise constitutional control functions through the judiciary or via other institutions. It's due to mention that even in the countries where constitutional courts have been established, it's quite complicated to find two absolutely similar models of constitutional review. In its opinions, the Venice Commission has noted that while there is no general requirement to establish a constitutional court, the establishment of such an organ as a separate institution is generally recommended and has often proved to be a motor in implementing the rule of law in a given country. From this perspective, the initiatives of Kazakh authorities for the establishment of the full-fledged constitutional court in the country would be considered as a crucial step towards the promotion of constitutionalism and increasing respect towards the rule of law in the country. I would like to express hope that the process of transforming the Constitutional Council into the Constitutional Court in Kazakhstan would be done smoothly with the due respect towards the rule of law, constitutional values, the principles of independence of judiciary, and guarantee of human rights and fundamental freedoms. The Venice Commission will be pleased to continue its cooperation with Kazakh authorities for these important reforms. Ladies and gentlemen, once again, let me congratulate all of you on the eve of the occasion of the Constitution Day of the Republic of Kazakhstan and wish all the success to the organizers and participants of this important international forum. Rahmat.
Спасибо, господин Варданян.
Thank you, Mr. Vardanyan. Let me thank the Commission for another event and readiness to provide expert support to an important topic. The floor is given to Ms. Frauke Bachner, Director General of the Human Foundation for International Legal Cooperation, IZ. Please, the floor is yours, Mrs. Frauke Bachner.
Соединиться нам по онлайн.
Honorable Chairman Mami, distinguished guests, I hope you can hear me. It is a great pleasure and honor for me to extend my greetings on behalf of the German Foundation for International Legal Cooperation. Thank you very much once again for your invitation and the possibility to contribute to this excellent panel. A very warm welcome to all distinguished guests and representatives of our partners here today. I'm very happy to meet many of you again in this conference. With virtual possibilities, the world has definitely grown together. This way it is possible to participate in spite of pending further commitments for which I excuse myself later. Of the forthcoming Constitution on 30th of August, IZ extends, as everyone does, its sincere congratulations to the Republic of Kazakhstan. Congratulations to more than 30 years of independence. Congratulations to the topic you have chosen for this round table and the goals you are setting for the evolution of constitutional control. State transformation and reforms in constitutional control are challenges. However, they are also huge chances for any legal system and for the society. That has accompanied many of its partner states on their way to establish the constitutional complaint. Therefore, we are proud to be able to contribute to your roundtable with our distinguished German expert, Professor Astrid Weil-Rabenstein. She was appointed just as second Senate of the German Federal Constitutional Court in June 2020. She has held the professorship of public law at the Johann Wolfgang Goethe University in Frankfurt since October 2010. Dear Professor Weil-Rabenstein, we are very grateful for your valuable expertise and highly qualified contribution. The constitutional complaint to the Federal Constitutional Court not only plays a central role in the German legal system, it is also of high esteem in our society with a view to a guarantee of proper protection of the fundamental rights of citizens. Decisions of the Federal Constitutional Court often are landmarks. They are often pioneering for legal developments. The constitutional complaint in Germany has a long history. First, it was introduced in 1919 by the Bamberg Constitution in Bavaria. Later, it existed as a part of a federal law since 1951. And finally, the constitutional complaint was inserted into the Basic Law in 1969. Last year, IAZ already held an online seminar about the constitutional complaint with the Constitutional Council and Federal Constitutional Court of Germany. Today's roundtable takes a deeper look at the topic and shows your sincere interest to evolve the constitutional control and ensure the protection of fundamental rights. IAZ will be pleased to continue to support our partners in Kazakhstan in the future. Our relationship, as you know, dates back to 2009. Our cooperation with the Constitutional Council began in 2012. Other partners are the General Prosecutor's Office and their Law Enforcement Academy, the Supreme Court and their Academy of Justice, as well as the Ministry of Justice. We have been promoting the roundtable discussions of manifold current legislative projects. Today's roundtable clearly follows the path we have started together. The significance and directive of the Constitution has since been strongly emphasized during your annual conferences on constitutional law in August since 2012. We will continue to support the overall goal to modernize the legal and judicial system in terms of stability and development, as well as the expansion of all forms of political responsibility. Only the implementation of legal norms and procedures that facilitate fundamental rights and optimize the development of all stakeholders will eventually guarantee social, societal, and state transformation. In this process, the role of all stakeholders present here today cannot be overestimated. Thank you very much again for your year-long cooperation and trust, and thank you for your attention.
Спасибо вам, госпожа Бахлер.
Thanks a lot, Ms. Bachler. And despite the fact there is a big difference in time, you are online with your welcoming speech. We are very much happy to have you with us. And we'd like us to start a little bit later at 11 local time, because for participants this is a very early time. Ms. Bachler is impacting a lot during many years for development of our legal sphere for many years, and I'm sure our cooperation will develop itself intensively. Right now, we ask the floor to the ambassador of European Union of Kazakhstan, Mr. Kęstutis Jankauskas. Please, Mr. Jankauskas.
Good morning to everyone, distinguished Mr. Chairman, honorable representative of the government, guests from abroad, representatives of the Venice Commission, ladies and gentlemen, greetings to folks in Almaty, and particular thanks to Kazgu University for hosting us here today in the capital. It is a true honor to address such a distinguished group of experts in academia on the eve of the Student Day of Kazakhstan, and I'd like to extend my sincere congratulations to our Kazakh colleagues and friends on that particular occasion. This roundtable takes place in an uneasy geopolitical situation around the country, in the world, and in the country which is in the process of transformation. European Union is partner of Kazakhstan, and we are working to advance stability, prosperity, peace, trade, good governance, and human rights together. Throughout the years, European Union and its member states have shared best practices with our Kazakh colleagues, aimed at making its legal system in line with international standards and its own undertaken commitments. Which welcome to today's conference experts from 2 EU member states, Germany and Croatia. 10 years ago, in 2012, Kazakhstan became full member of the Venice Commission. legal cooperation has been intensified since then with several state institutions such as Constitutional Council. Many of its members are present here today, the Supreme Court, the High Judicial Council, the Ombudsman Institution, and the Parliament of Kazakhstan. The basis for our cooperation today is the Enhanced Partnership and Cooperation Agreement, the first agreement of that kind in Central Asia, which is now fully in force since 2020. In this agreement, Kazakhstan and the European Union have agreed, and I quote, to attach particular importance to the promotion of the rule of law, including the independence of the judiciary, access to justice, and the right of a fair trial, the respect for human rights and fundamental freedoms. The parties shall cooperate in strengthening the functioning of institutions, including law enforcement, prosecution, administration of justice, and the prevention of and fight against corruption, end of quote. 2 years ago, in 2020, we launched Joint Council of Europe and European Union Central Asia Law Program. That program covers several years. It will continue until the next year, and we are happy that the Venice Commission is one of the components of this program. It has provided targeted technical expertise in the field of constitutional reform, analysis of existing and draft legislation, and the functioning of state institutions and judiciary in Kazakhstan. The program is regional, so it is also my pleasure to welcome today the representatives of the neighboring Central Asian states. Let me say it very straightforward. Today, more than ever, when international rules-based world order has been brutally violated, we all see the need to reinforce the international law. Equally, at home, we all need to create a model of law enhancing and enabling our citizens to feel that their rights are protected. Kazakhstan is currently undertaking serious reform, modifying its constitutional order. The European Union welcomes political reforms initiated by President Tokayev on March 16, in addition to socio-economic reforms which started after the tragic events in January. We welcome the decision to consult the population directly during the referendum in June. In that referendum, it has been decided to transform the Constitutional Council into the Constitutional Court. It should widen the possibility for citizens to apply when needed and to provide possibilities to assess the law and its compliance with the highest law of the country. The European Union stands ready to assist Kazakhstan and its authorities in the implementation of these decisions into practice. The implementation is always extremely important. I would also encourage the use of the Venice Commission. Its experts are ready within the scope of the ongoing program to provide the legal opinion on the draft laws concerning the Constitution of Kazakhstan, the reforms of the judicial system, the Ombudsman administrative procedure, of course, the Constitutional Court. I hope that today's conference will provide timely opportunity to discuss the implementation of ongoing reforms, which in turn will help to strengthen Kazakhstan's independence, resilience, attractiveness, progress. It will also strengthen the partnership. I wish all the participants successful work today.
Thank you, dear Mr. Ambassador. The Constitutional Council of Kazakhstan will continue their efforts for the successful implementation of the program of the European Union and European Council on the rule of law. Dear participants, now we proceed to the reports to the plenary session. According to the program, our first speaker will be the member of the Constitutional Council of the Governmental discussions and questions and answers will be possible after all the reports. The speakers are kindly asked to follow the timetable. The floor yours. Good afternoon. He is joining us from Astana, the capital of Kazakhstan. Good afternoon, dear participants of the roundtable. As you know, Kazakhstan has been implementing a large-scale program of political modernization since the beginning of the year. It involves a transition to a new state model, a new format of interaction between the state and society. All these questions are directly related to the constitutional measure. In this regard, especially the working group worked on the legal formation of the ideas put forward by the head of the state. As a result, a draft law on amendments to the Constitution was prepared, which was published in the mass media on May 6th. The President of the Republic decided to submit the bill to the public referendum, which took place on the 5th of June. Thus, the path was chosen to use the most democratic way to change the constitution, and every citizen of the country was able to express his or her opinion on the proposed innovations. Constitutional changes can be divided into several blocks. The first amendments intend to consolidate the final transition from the super-presidential form of government to a presidential republic with an influential parliament and accountable government. In this respect, the head of the state has transferred a number of powers to other state bodies or will exercise them in agreement with them. In order to increase the political competition, a requirement has been introduced. The president should not be a member of a political party for the period of exercising his powers. Many changes relate to strengthening the role of the parliament and local representative bodies, improving the legislative process. In this regard, the procedure for the formation of both chambers of parliament has been revised. The presidential quota in the Senate has been reduced from 15 to 10 deputies. Moreover, 5 of them will be proposed by the Assembly of the People of Kazakhstan. This will provide mandates to various ethnic groups in the upper house. A decision was made to introduce a mixed majoritarian proportional electoral system for elections to the Majlis. 30% of the lower house will be elected in single-member constituencies. This will better reflect the interest of voters. At the same time, citizens have the right to recall the elected deputy if they fail to fulfill their election promises. Its application, according to the experts, and they are right, will contribute to the establishment of a new political culture based on mutual responsibility and trust. The innovations of the legislative process include submission by the parliament and not the Senate to the signature of the law to the president, adoption of constitutional laws at a joint session of the chambers. In order to promptly respond to conditions that pose a threat to the life and health of the population and other values, government has been granting the right to adopt temporary regulatory legal acts that have the force of law. As you understand, the pandemic and other modern threats show the need for such urgent actions. Preliminary control over the quality of execution of the Republic national budget is being strengthened. To do this, the committee is transferred into the Supreme Audit Chamber, the chairman of which must report twice a year to the Majlismen. The guarantees of the local state administration and self-government are being strengthened. Now, regional hakims are appointed by the President of the Republic with the consent of the deputy, all maslihats located in the region, and not just the regional maslihats. At the same time, the head of the state proposes at least 2 candidates. The President retains the right to dismiss only hakims of regions and also abolishes his right to cancel the acts of these hakims. An important set of amendments concerns the issues of the law enforcement system. to finally consolidate the decision to the death penalty, which was made that this type of punishment is prohibited. The constitutional status of the Commissioner for Human Rights has been strengthened, and a separate constitutional law prosecutor's office has been envisaged. Especially, I'd like to highlight the transformation of the Constitutional Council into the Constitutional Court with the expansion of the list of subjects of appeal. The Constitutional Council, established after the adoption of the current Constitution, has made a significant contribution to the formation and development of the national legal systems. At the same time, modern realities present new requirements. At present time, a draft constitutional law on constitutional when developing it, the domestic experience of constitutional control for 30 years, international practice, proposals from the legal community, as well as achievements of the legal science were taken into account. Structurally, it contains of 3 sections. The first section contains the norms regulating the mission of the Constitutional Court, the procedure for its formation, requirements of judges, guarantees for their activities, issues of material and social security. The Constitutional Court is defined as an independent body that is not a part of the judicial system, which ensures the supremacy and the rule of the Constitution throughout the country. The competence of the new body has been determined, which will contribute the function of both preliminary and subsequent control. He retained all the powers of the Constitutional Council. At the same time, it has established that the Constitutional Court decides exclusively on issues of law and does not assess the actual circumstances that gave rise to the appeal. Judges of the Constitutional Court are defined as persons holding responsible public positions. They will not belong to the category of political servants, as it is now stated in relation to the members of the Constitutional Council. The second section systematizes the norms concerning the procedure for conducting constitutional proceedings. The draft outlines the principles of constitutional proceedings. These include the supremacy of the Constitution, a comprehensive, complete and objective study of the circumstances of the appeal, collegially publicity, equality of participants, etc. When considering appeals, proceedings may be combined with written proceedings, taking into account modern realities. An electronic format has also been laid down. In the future, it is planned to create an information platform that will be integrated with some resources of state bodies and will cover all stages of constitutional proceedings, from filing to uploading the decision. A new classification of subjects participating in constitutional proceedings is proposed. The first group consists of participants in constitutional proceedings which are recognized as subjects of circulation and state bodies, the constitutionality of acts of which is checked. The second group includes persons and bodies involved in the consideration of appeal. These are state bodies and organizations, and others that are endowed with procedural and bear certain duties. An important part of the draft is the provisions regulating the procedure and conditions for citizens applied to the Constitutional Court. The Constitutional Court, at the request of a citizen, will consider for clients with the Constitution of the Republic of normative legal acts that directly affect their rights and freedoms enriched in the Constitution. In countries before applying Constitutional Court, citizens must exhaust all other funds to be protected. So, activity by the constitutional control considered how subsidiary protection mainly rights person. It is planned to introduce a state duty for citizens, the amount of which will be optional. The activity, if we talk about the constitutional control body, will be considered and decided based on the draft law as a subsidiary mechanism for the human rights protection. The government duty is planned, which size will be optimal for the citizens. The category of benefits like disabled people and participants of war, will be provided for in connection with the increased appeal of the citizen. There is a two-stage process of consideration, and the requirements state which will have to be complied with, they will be determined to the providing persons, and this practice exists almost in all authorities of the constitutional control abroad. The appeals which have passed the preliminary selection will be provided to the constitutional court judges. Mediator might have the right to demand the judgment of the court. For the purpose of optimal distribution of the load, there is a possibility to consider the case participation of all judges. For example, 3 judges may consider and decide on the case with application of the citizen consisting of not less than 5 judges. The procedure of application and consideration will be prescribed by the law, and the required materials will be provided, and the experts will be involved to support the judgment of the court to ensure the proper consideration of the appeal. Also, there is a legislative determination of the differentiated terms of appeal, 1 month period and 3 month period for the citizens. The complex nature of the appeal provides for extension of the term, but the interested parties should be informed therefore. Take into account the importance and urgency of some appeals received by the Constitutional Court, it may make a decision to consider it faster. The legislation provides for the grounds to suspend and terminate of the constitutional proceedings, breaks in the court hearings to complete the procedural aspects. A separate article is devoted to the issue of the Constitutional Court. They are adopted in the form of resolutions which are an integral part of the current law of the Republic, messages, conclusions, as well as ordinary decisions on procedure and other issues. The requirements or requisites for the content of the normative resolution and conclusion of the Constitutional Court are established. Separate articles regulate the issues of making an additional decision of revising the decision of the Constitutional Court. Of great value are the provisions concerning the legal consequences of the decision of the Constitutional Court. The Constitutional Court, like the Council now, will be able to determine the procedures for the entry into force and execution of its decision. He is given the opportunity to determine the date from which the legal norm recognized as constitutional is repealed. The draft law contains tools to ensure the execution of the decision of the Constitutional Court. If it results in the need to take legislative measures, the authorized state bodies ensure that a draft of the relevant law is submitted to the Parliament not less than 6 months before adoption of a new legal act. The Constitution and the decision of the Constitutional Court are directly applied, of course, taking into account the peculiarities of the legal regulation that affect public relations. These are the main provisions of the constitutional law and the Constitution of the Republic of Kazakhstan. Dear participants, the developed draft of the constitutional law is intended to create legal grounds for the activities of the Constitutional Court. Some of its provisions will be detailed in the regulations and other internal acts. There is a lot of work ahead. As the Chair has said, we are ready to consider all your recommendations and suggestions. I wish you fruitful work and thank you for your attention and congratulations to the coming Constitution Day. Thank you for your attention. Thank you very much, Yogan Davidovich. I hope that the ideas expressed by you will be developed in subsequent reports. The next word is given to the Chairman of the Constitutional Court of the Republic of Uzbekistan, Mr. Mirza Ulugbek. Abdusalomov. Please, the floor is yours.
Good day, dear ladies.
Good day, ladies and gentlemen. Good day, dear Mr. Chairman. Let me welcome you and express my gratitude to the organizers of today's event, the Constitutional Council of the Republic of Kazakhstan and the Commission of the Council of Europe for the invitation to the International Roundtable and the opportunity to speak to you. Let me thank you for this opportunity to be with you, to the rector and the professor of Narhoz University. This is a great university. We can relate you with this fact. The university is one of the best in Kazakhstan, and not only in Kazakhstan, and also Central Asia. In the Constitution of the Republic of Uzbekistan, which was adopted on December the 8th, 1992, served as a solid legal basis for all the successes and achievements of our country during the years of independence. The President of the Republic of Uzbekistan, Shavkat Mirziyoyev, in his congratulations to the people of Uzbekistan on the occasion of the 29th anniversary of the adoption of the Constitution, noted that in order to implement the tasks that are important in building a just, true people's state, first of all, a constitutional foundation and even more solid the legislation framework is required. In this sense, harmonization is the basic law with the modern realities of our society, the essence of our constituent reforms, as well as creation of a solid legal foundation for the development strategy of new Uzbekistan becomes an important task. This issue especially emphasized in the proposals to citizens, the general public and representatives of political parties during the meeting held before the presidential elections. The main directions of constitutional reforms were determined by the President of Uzbekistan in this document. Taking this opportunity, I would like to briefly inform you about the ongoing constitutional reforms. On May 20th, 2022, by resolution of Kengashev Chambers of Parliament of Uzbekistan on measures for implementation and constitutional reforms, the Constitutional Commission was formed to formulate proposals for amendments and additions to the Constitution. And on June 24, 2023, the Legislative Member of Parliament of Uzbekistan adopted the drafted constitutional law of Uzbekistan, amendments and additions to the Constitution prepared by Constitutional Commission based on study of more than 60,000 proposals. And in the draft constitutional law, it was aimed to consolidate a constitutional norm, the principles of man's society and state. The new Uzbekistan is social state, building a human state, strengthening the protection of human rights and social protection, fully ensuring the rights and interests of both. Also, changes were related to the consolidation at the constitutional level of such issues as the organization of high quality and qualified medical care, the development of education, the guarantee of inviolability of private property, and the status of civil society institutions and environmental protection. At the same time, the draft law also includes issues to improve the system of state power and administration, including expanding powers of parliament, improving the institution of the presidency, and supporting representative and executive bodies of power at local level. The draft law also provides for a new rule that the Constitutional Court considers complaints from citizens and legal entities to verify the compliance with the Constitution with the law applied to them by court in a particular case. The draft constitutional law was published in the media for a nationwide discussion, which was held until August 1st, 2022. At present, the responsible legislative chamber continued to work to examine and analyze more than 150,000 proposals. After approval by legislative chamber, the draft constitutional law on amendments and additions to the Constitution of Uzbekistan will be submitted to national referendum and will be adopted at a referendum. This practice was recently taking place in Kazakhstan, and the law of Kazakhstan on amendments and additions to the Constitution of Kazakhstan, dated the of June 2022, was adopted at Republican referendum. The relevant amendments and additions to the Constitution of Kazakhstan correspond to the issues of constitutional judicial control, which will now be carried out by the Constitutional Court of Kazakhstan, which undoubtedly deserves approval. Dear participants of the Round Table, let me advise you that in the Republic of Uzbekistan, special attention is also currently paid to improved constitutional court. On April 27, 2021, a new constitutional law on the Constitutional Court of Uzbekistan was adopted, and the development and adoption of which provided by the National Strategy of Uzbekistan on Human Rights, approved by decree of the President of Uzbekistan in June 23, 2020. As it is known, the institution of constitutional complaint is an effective means of protecting fundamental human rights. The new law is primarily aimed to strengthen the human rights function at the Constitutional Court. In particular, the circle of entities applying to the Constitutional Court has been extended. Among them, there are citizens and legal entities, National Center of Uzbekistan for Human Rights, the Commissioner under the President of Uzbekistan for Protection of Human Rights and Legitimate Interests of Business Entities, Business Ombudsman, and the Commissioner of Children's Rights. Totally, there are 15, and the law provides that citizens and legal entities have the right to apply to the Constitutional Court with a complaint to review the constitutionality of the law. And in their opinion, if it violates the constitutional rights and freedoms, then does not comply with the Constitution and can be applied in a specific case for the consideration to the court. And from now on, citizens and legal entities who believe that their rights and freedoms are violated by law and does not comply with the Constitution, they can apply directly to the Constitutional Court. And the constitutional law establishes that a constitutional complaint must be filed not later than 1 year from the date of completion of the consideration of the case in the court. The end of consideration of the case in court, in fact, means that the person has used all the possibilities before applying to the Constitutional Court. The Institute of Constitutional Complaint in Uzbekistan has built the model partial complaint, since the subject of appeal is the law and not a normative legal act anymore. The application of the constitutional complaint leads to a sharp increase in the number of citizens' appeals to the court. However, as an analysis of statistics of citizens' appeals shows, a significant number of complaints turn out to be inadmissible and unfounded on formal grounds. Therefore, most appeals are screened out at the preliminary stage of study, since the decision of many of them does not fall within the competence of Constitutional Court. For instance, in 2021, the Constitutional Court received about 1.5 thousand appeals from citizens. Out of them, 250 appeals raise those issues, the resolution of which falls within the competence of the Constitutional Court. And in the first half of this year, the Constitutional Court received about 700 of appeals, of which 97 appeals raised those issues, the resolution of which falls within the competence of Constitutional Court. The law established a specific requirement for applying the Constitutional Court. An appeal to the Constitutional Court should be sent in writing or electronically, and the appeal must include the following: name, date of adoption, source, application of normative legal act, and constitutionality for verification. Legal grounds, the position of applicant, and as noted, the constitutional complaint is implemented in the form of the specific control. Therefore, the complaints of citizens and legal entities are in fact for the consideration of the case court, and the use of all forms of judicial protection should be indicated. The Constitutional Court shall start to study the appeal not later than 7 days from the date of receipt, and within 3 months must take an appropriate decision. Article 4 of Constitutional Law on the Constitutional Court of Uzbekistan establishes the rule that the Constitutional Court, in exercising its powers, refrains from establishing and investigating circumstances, and in all cases, when this falls within competence of other courts and their bodies, and it loses the jurisdiction. And the regulatory legal acts of the individual parts recognizes as not in accordance with the Constitution cease to have effect and lose their legal force. State bodies that have taken decisions on the basis of a normal legal act recognizes as inconsistent with the Constitution must review decisions within 1 month. So, it should be emphasized that decisions of the Supreme Court or lower courts are not appealed to the Constitutional Court. As a part of constitutional complaint, the applicant may prove the provisions of law that has applied a particular case that is contrary to provisions of Constitution. And summing up the results of the analysis of Institute of Constitutional Complaint, it can be argued that the option of the new constitutional law on the Constitutional Court of Uzbekistan serves to constitutional control, strengthen the rule of law, and improve constitutional legal proceedings, and ultimately effectively protect the rights and freedoms of citizens guaranteed by Constitution. Describing the model of constitutional complaint in Uzbekistan, it should be noted that the institution of a constitutional complaint is in its infancy now. The step is to expand the rights of citizens to access constitutional justice, and could be the inclusion into constitutional law on Constitutional Court of Uzbekistan of provisions providing the possibility to change the constitutionality of not only the laws but also other normative legal acts. return to the model of a full constitutional complaint in Uzbekistan can be implemented in the future with the improvement of legislation. The introduction of this model should be phased, taking into account the development of practice of constitutional complaints. And this, in turn, requires improvement of organizational work at the Office of Constitutional Court. In conclusion, let me note that the ongoing constitutional reform and the implementation of the norms of the new constitution on the Constitutional Court of Uzbekistan will increase effectiveness and constitutional control. Thank you very much for your attention. Thank you very much, dear Mr. Mirzalukbek Alchevich, for meaningful presentation. You have clarified many issues, and I'm sure that your experience on the constitutional reforms will be very useful for us. And now let me give the floor to Ms. Astrid Rabenstein, who is the judge of the Federal Constitutional Court of Germany. The floor is yours, Ms. Astrid Rabenstein.
Good morning, Honorable Chairman, dear Ms. Bachler, distinguished guests. First, let me congratulate on behalf of the Federal Constitutional Court to your Constitutional Day tomorrow in Kazakhstan. I'm happy to share a brief overview on the constitutional complaint in Germany and on the way how the Constitutional Court in Germany deals with it with you. Constitutional complaints account for the overwhelming majority of proceedings before the Federal Constitutional Court. In 2021, registered proceedings recorded a total of 5,352 matters, and of these, 5,009 were constitutional complaints, which amounts to 95%. These figures are roughly consistent with the average case numbers recorded since the early 1990s. Constitutional complaint proceedings play a significant role in how court is perceived in the public in Germany. We often are a court as a citizen's court, not least because anyone may challenge an act of German public authority by filing a constitutional complaint. Domestic legal entities may lodge constitutional complaints as well, with the exception of public sector entities. Complainants do not require legal representation and no court fees apply. At first glance, access to the Federal Constitutional Court is designed in a way that makes it remarkably easy for individuals to approach the court. Constitutional complaint allows individuals to challenge the state as an equal, despite all the power the latter holds, and to assert their rights against state authority exercised, for example, by the Federal Court of Justice, the legislator. This is certainly a factor contributing to the overall positive perception of trust enjoyed by the court among the general public. From a French perspective, constitutional complaint proceedings entail remarkable authority on the part of the court. No act of public authority is per se exempt from the possibility of a constitutional complaint and the court's power to review and potentially set aside act. Consequently, all decisions must effectively respect and uphold fundamental rights as a system of values underpinning the entire state order. These two interrelated aspects are key to understanding why the historically low prospects of success for constitutional complaints. Less than 10% of complaints are successful, while this do not appear to have a negative effect on the public trust enjoyed by the court. As a rule, judicial review conducted by the ordinary, the regular courts already takes into account fundamental rights considerations and In the great majority of cases, the regular courts ensure that fundamental rights are served. Against this backdrop, when the Federal Constitutional Court does grant a constitutional complaint, its decision tends to have a magnificent impact. Given the steady influx of proceedings, how does the court, do we manage this caseload? I've outlined 3 procedural and organizational mechanisms in this context. First, submissions received subject to a preliminary assessment conducted by legal officers working in our general register, all of whom are German lawyers qualified to hold judicial office. As I mentioned, more than 5,000 proceedings are lodged every year. However, the actual number of submissions is nearly twice high, as thousands of additional submissions reach the court on a regular basis. When the preliminary assessment includes the submission constitutes a constitutional complaint, but one that is clearly inadmissible, for example, a complaint that was not filed within the statutory time limit, the complainants are notified and informed about the reasons why the complaint has no prospects. If, upon receiving this notification, the complainants still insist on a judicial decision, the constitutional complaint is transferred to the register of proceedings as a case to be decided by the court in the regular procedure. My second point, constitutional complaints are only admitted for decision if they meet specific substantive standard. The complaint will be admitted for decision if it has general constitutional significance or if it is appropriate to enforce the fundamental rights asserted by the complaint. The decision not to admit a constitutional complaint is taken by a smaller panel composed of only 3 judges, so-called chambers. While the chamber based its decision on an internal report prepared by judicial clerks, which details exactly why the constitutional complaint has no prospect of success, the decision rendered by the chamber is usually issued without reasons, and that takes a lot of time. Under certain conditions, the chamber may not only decide on the issue of a constitutional complaint, but also recommend taking burden off the Senate's dockets. The chamber may grant the relief sought if the issues of constitutional law raised in that case are already settled in the court's case law, which is, thanks to our more than 70-year-long jurisdiction, quite often the case. Last year, 4,999 constitutional complaint proceedings were concluded by the chambers, whereas only 10 were concluded by a decision. Most constitutional complaints are not admitted for decision on the grounds that the complaint fails the procedural requirements of admissibility. The 4 substantive requirements that must satisfy for admissibility are indeed quite strict, and I want to point out the most important ones. Complainants must first seek resource to the ordinary courts and then must exhaust legal remedies in that regard before filing a constitutional complaint. It is therefore incumbent upon complainants to take every measure available during the proceedings before the ordinary courts to prevent or remedy a violation of their fundamental rights. Ultimately, this means that complainants must first invoke and assert such rights before the ordinary courts. We take the principle of subsidiarity of constitutional complaints in relation to legal protection that can be sought before the ordinary courts very seriously. Constitutional complaints must be filed within 1 month after the complainant is notified of the last decision rendered by the authorities or courts in that matter. The complainant brief submitted to the court must provide comprehensive and sufficiently supported reasons and include all relevant procedural documents and files from the leading administrative judicial proceedings, so as to allow the court to be able to conduct a constitutional review on that basis alone. To that end, it is not sufficient for complainants to demonstrate that the court's decision contains a legal error. Rather, complainants must demonstrate why such error could amount to a specific violation of constitutional law or fundamental rights. Many constitutional complaints fail to meet this standard. It might happen that an ordinary court hands down a decision that does not quite get everything right in every respect. But instances where courts actually violate the constitutions are fortunately quite rare. From a functional point of view, procedural prerequisites ensure appropriate distribution of tasks between the Federal Constitutional Court on the one hand and the ordinary courts on the other. It ensures that the law and facts of a case have already been thoroughly prepared and examined by the ordinary courts before a matter reaches the stage of a constitutional review in the Federal Constitutional Court. Many issues raised by complainants are already adequately addressed in ordinary legislation, and in many cases can be resolved sufficiently by the ordinary courts. In such a decentralized system, legal protection is ultimately administered much more effectively. And the Federal Constitutional Court's responsibility is today mainly to ensure that it stays that way. I want to conclude with some remarks on the review of statutes because you asked for this. Constitutional complaints were directed against court decisions. In some cases, however, the constitutionality of the law is changed, and it is these cases that attract a lot of attention. Within 1 year of a law taking effect, it can be direct with a constitutional complaint, provided that the complainants can demonstrate that they are directly affecting the law, and this is seldom the case. But it is also possible to indirectly change the constitutionality of a law by filing a constitutional complaint against the court decision based on the contested law. Lastly, a court may refer a law on which its decision in a pending case depends to the Federal Constitutional Court for review and for request that the law be declared unconstitutional and void. In Germany, only the Federal Constitutional Court has the power to declare laws enacted by Parliament void. However, out of respect for the other constitutional organs, and that is here for the legislature, and because of legitimation conferred on it through direct democratic elections, the Federal Constitutional Court exercises a particular restraint in such cases. When it comes to balancing fundamental freedoms and the legitimate interests invoked to justify restrictions of freedoms, the court recognizes that the legislature is, in principle, afforded a margin of appreciation and as well as a margin of prognosis in assessing the effects of legislation. Further, the Federal Constitutional Court has developed more refined options in setting out the legal effects of a constitutional court ruling, with a view to preserving the leeway of the legislator even if the court's decision finds a law unconstitutional. In principle, the court may declare an unconstitutional law void from the outset. In reality, however, the Federal Constitutional Court rarely opts to declare a law void, because declaring a law void would often lead to consequences that are even further removed from the constitutional than the unconstitutional law itself. least because such laws, despite their constitutional deficits, often serve the protection of legitimate and in many cases very significant legal interests. In such cases, the court may opt to declare law only incompatible with the Constitution instead of void. It may then order that the law remain in force until the legislator enacts new legislation to rectify the constitutional deficiency. In this regard, the court usually sets a deadline for the legislator to pass a new legislation, and usually the legislator follows this deadline. The relationship between the Federal Constitutional Court and legislature is shaped by the spirit of dialogue. The basis of constitutional dialogue is the shared belief that interpreting and further developing constitutional values continues an ever-evolving process for which all constitutional organs bear equal responsibility. Thank you for your attention.
Thank you, Ms. Lauerstein, for your congratulations and for your interesting report. Your comments would be really useful for the work of the future Constitutional Court of our Republic. The next floor is given to Ms. Jasna Majek, ex-president of the Constitutional Court of the Republic of Croatia, member of the Venice Commission.
Thank you. Thank you very much, President. I'm waiting for my PowerPoint presentation. Yes, that's it. So, shall we start? Dear Mr. President, ladies and gentlemen, dear colleagues, it is with great honor and pleasure that I address you today at this important conference dedicated to the Constitution Day of the Republic of Kazakhstan. I have prepared a comprehensive written paper on the subject I'm discussing here. Hoping you have already received the paper, I will present here only the basic thesis. I would like to note that the views I express here do not necessarily reflect the view of the Venice Commission. To make my speech as straightforward as possible and perhaps less boring, I have prepared a PowerPoint presentation that will run together with my speech. Forgive me if during the speech I repeat facts that have already been said or are known to everyone. Now, please allow me to extend my sincerest congratulations to all the citizens of Kazakhstan for the 27th anniversary of the adoption of the Constitution. This is a State of the Nation address from March 2022. President Tokayev announced the introduction of the crucial measure in the field of human rights protection in Kazakhstan to reform the national constitutional judiciary, establishing the Constitutional Court instead of the Constitutional Council, and also citizens to appeal directly to it. You can see a relevant part of his address at the screen. The Venice Commission recently found that the Kazakh model of constitutional justice comes closer to the European continental model of concentrated constitutional review based in a single-state body. That means the Constitutional Court. We all know that the father of the European continental model is the Austrian scholar Hans Kelsen. It seems that Kelsen's initial idea of the definition of jurisdictions was clear. Simply put, all constitutional matters should be localized within the Constitutional Court. In contrast, the resolution of all disputes involving the application of ordinary legislation should be exclusively of the ordinary courts. The further development of the constitutional judiciary has not followed this initial Kelsen's idea strictly. Today, there are two main points of contact, which are also sources of possible conflict in ordinary and constitutional courts. The point of contact is the so-called concrete constitutional control of the norms. In most systems, if an ordinary court finds that a legal norm, which is to be applied in a concrete case, is unconstitutional, it may or must interrupt the court proceedings and refer the question of constitutionality to the Constitutional Court. The Kazakh constitution has recognized the concrete control of legal norms since 1995. Article 78 of the Constitution is presented on the screen. It follows from this article that the ordinary court must satisfy itself that the legal norm, which it must apply, violates the constitutional rights and freedoms of the party. This specific common condition is important for our discussion here. Since 1995, less than 75 these cases have reached the Constitutional Council. It seems that one of the aims of the 2022 constitutional amendments is to operationalize this procedure, which is not sufficiently used by the ordinary courts, in order to strengthen the human rights elements of the Constitution, as Mr. Rogov recently pointed out. So the question is, in what way will the human rights element be strengthened in Kazakhstan? The answer is, in a way, that the citizen is allowed direct access to the Constitutional Court by submitting the so-called constitutional complaint. In some systems, a complaint can only be directed against a legal norm that the ordinary court applied to resolve the party's case. If it is the so-called normative constitutional complaint. In other systems, a complaint can also be directed against a court's decision itself, as in Germany. It is the so-called full constitutional complaint. By the 2022 constitutional amendments, the Kazakh constitution has opted for the normative constitutional complaint. You can see Article 72 of the Kazakh constitution on the screen. The part of the provision which reads that directly affect their rights and freedoms clearly shows that the Kazakh constitution does not permit individuals to complain against the law in abstracto. On the contrary, it is necessary that the legal norm which is applied must violate the constitutional right of the party. From a procedural point of view, and giving a Kazakh constitutional framework, to be directly affected by a legal norm could mean also, as a rule, that there is a specific case before the ordinary court, and the legal norm that the party considers unconstitutional must be applied to that case. In this light, it is of the utmost importance how the Kazakh legislator will stipulate the procedures and conditions for the citizens' appeals to the Constitutional Court. It seems to me that two main types of proceedings can be instituted when it comes to the possibility for citizens to apply to the Constitutional Court directly. In the first possible type of proceedings, a person who has already lost their case before ordinary courts can complain before the Constitutional Court, claiming that their constitutional rights have been violated by the legal norm
that the ordinary courts applied in the party's case. The first main condition for submitting a normative constitutional complaint in this situation is for the party to exhaust the appeal rights and any other effective legal remedy during the course of ordinary court proceedings. The second main condition for submitting a normative constitutional complaint in this situation is the case to be res judicata. However, this type of proceeding opens up many questions, despite its procedural simplicity. As we have already mentioned, Article 78 of the Kazakh Constitution, the ordinary court is obliged by itself to refer the question on constitutionality to the Constitutional Court if it finds that a legal norm to be applied infringes upon the constitutional rights of the party. Therefore, it seems necessary to find an adequate procedural mechanism to harmonize the obligation of the ordinary court prescribed in Article 78 and the right of the party prescribed in the amended Article 72 to appeal to the Constitutional Court on the same question that the ordinary court itself is obliged to raise before the Constitutional Court. This brings us to another possible type of proceedings. In this type, the party would be obliged to ask the ordinary court to refer the preliminary question of constitutionality of the legal norm to the Constitutional Court. Of course, if the party has doubts concerning its constitutionality. It would be the party's first procedural step. Would the party have the right to appeal? In my view, the first instance court's decision to deny the party's motion would not be subject to an appeal. Instead, if the first instance ordinary court denies the party's motion, the party would have a right to file the motion again at the beginning of the appellate proceedings and every ordinary court instance thereafter, if provided by the law, of course. This would be the party's second procedural step. Each higher court instance would decide on such a motion ab ovo, as if were the court of first and last instance that needs to decide whether or not to refer the question of constitutionality to the Constitutional Court. Unfortunately, there is no time for the explanation of this second procedural step, very important one, in more details, but it is explained in my written report. So let us sum up the steps. The first main condition for the party to have locus standi before the Constitutional Court would be the obligation to initiate the question of constitutionality before the ordinary court or any level at which the party's case is decided. And all these motions must be denied by the ordinary courts. Second, the final decision on merits of the last instance ordinary court must become enforceable. If these conditions were fulfilled, it will be presumed that the party has exhausted all legal remedies as a precondition for filing the normative constitutional complaint with the Constitutional Court. It will be the third and the last party's procedural step, second type of proceedings. Of course, it's really a very rough framework, and there are other possible models, but this one seems to be the most. Let's move on the last issue I want to discuss today. As in all modern states, the Kazakh constitution prescribes that the state power in the Republic of Kazakhstan is based on the principle of its division into the legislative, executive, and judicial branches. The relevant article of the Constitution is presented on the screen. In this light, the last question is, which branch of power does the Constitutional Code belong to? There is no single answer to this question. On the one hand, in some countries, constitutional codes are a part of the judiciary. The best known example is the German Federal Constitutional Court. However, it is essential to know that this court has been distinct from the federal judiciary for the last 70 years due to the so-called status memo, by which the court asserted itself as a constitutional organ standing on an equal footing with the federal legislature or the federal president. On the other hand, in some other countries, the constitutional codes are not part of the judiciary. Croatia, as a typical European post-communist state, can serve as an example. In Croatia, the Constitutional Court forms the so-called fourth branch of power. However, it is not considered as a superior state organ to the three branches of government. It is considered as an interplayer, a state authority which permeates all other unconstitutional matters. If you look at the structure of the Kazakh constitution, it seems that the Constitutional Court is in a similar constitutional position as it is in my country. I would also emphasize that Article 1 of the Constitutional Act on the Constitutional Council from 1995 is very well structured and contains all necessary elements for defining the Constitutional Court as an independent and separate constitutional organ of the Kazakh state. It is a huge effort should be invested in finding the optimal model of constitutional complaint at the national level, introducing it in practice and bringing it closer to the public. The protection of human rights and mental freedoms is our common task. This can be important and it can never be taken for granted. But our task is far from being completed. We must continue to reflect and adapt to the changes that our society is going through. We must retain our purpose to ensure that democracy, human rights, and the rule of law are respected everywhere and every time. I wish that the Constitutional Court of Kazakhstan be recognized in society as the institution where justice is done within the framework of principles enshrined in the Constitution of the Republic of Kazakhstan. Dear Kazakhs, let me once again warmly congratulate you on the 27th anniversary of your Constitution. And thank you very much for your attention.
Вам спасибо, господин.
Thanks a lot, Ms. Olmeyek. You have explained in very details the European experience of constitutional claim provided for citizens. We hope to see you in Kazakhstan in the nearest future, and that you would be a part of the constitutional bodies of Kazakhstan. And right now, we give the floor to Mr. Jang Won-Kim, the Deputy Secretary General of the Constitutional Court of the Republic of Korea, who is the deputy member of the Venice Commission. Mr. Kim, the floor is yours.
Thank you, Chairman Mr. Mami. As one of the participants far and wide, it's an honor to share the value of the Constitution in this round table today. I want to talk about the characteristic of constitutional complaint in South Korea. In 1987, Constitution of Korea provided the ground for the constitutional complaint without going through the ordinary courts. In this account, an individual may directly file a request to the Constitutional Court. The Constitutional Court Act, based on this Constitution, was enacted in 1988. Then, one of the most controversial issues was whether the ordinary court's decisions should be included in the subject matter for review in a constitutional complaint. During that time, West Germany's system served as a model for the constitutional complaint. The global leaders and scholars took the position that ordinary court's decisions should be the subject matter for review in a constitutional complaint. On the contrary, the Supreme Court was against it. After these pros and cons, we discovered an alternative as a bargaining tool. A detour had been made. Instead of absorbing ordinary court's decisions into the arena of a constitutional court, instead, an individual was allowed directly to be accessible to constitutional court in case of an ordinary court's rejection of the request for a referral. 2020 alone, the number of cases of constitutional complaints registered by the individuals whose applicants were rejected by ordinary courts reached 700. The gray line, the graph is expressed in my own speech. Let me skip this part. Constitutional complaints in Korea have the following cases. The court's decision on whether application for referral to the Constitutional Court is granted or not cannot be revoked. There is no review of a higher court against such a decision. In France, the referral would be made by the highest court, Conseil d'État or Cour de Cassation. The absence of filtering by higher court may cause the confusion to lower level courts. That implies both a positive and a negative function. The good side is that the referral by ordinary courts might be more accurately. The bad side is that contradiction between ordinary courts may arise. In case an ordinary court rejects an application for referral, the applicant could file a constitutional complaint directly to the Constitutional Court. If the Constitutional Court declares the law unconstitutional, the effect will bind all the ordinary courts. If the case stayed in the ordinary court, it should not apply the law. On the contrary, if an ordinary court's decision were made during the procedure of the Constitutional Court, the applicant would have the right to request a retrial to an ordinary court. When the constitutional complaint system is introduced, surely the burden of case on the shoulder on the Constitutional Court will increase. Therefore, it is strongly advisable that an efficient system for handling case is established. The efficiency of handling the case depends on the appropriate allocation among the full bench and the chamber. The composition of the chamber and the preparation of procedure rules are essential. It is very important to draw up measures to harmonize speed and accuracy. A regular evaluation of the system should be made, and a continuous improvement plan should be sought out. Now, I will refer to judgments delivered from the Venice Commission in view of the case of Korea. I am convinced that the Constitutional Council of Kazakhstan has made a great contribution to the people of Kazakhstan. the launch of the Constitutional Court is truly encouraging. I understand that the Constitutional Court and the Supreme Court have been established at the same level among state bodies in Kazakhstan, in similarity with South Korea. In case of Germany, the Constitutional Court is placed as the highest level over the Supreme Court. The exhaustion of remedy is required to file a constitutional complaint in South Korea. Since the Constitutional Court is the last resort in the process of redressing basic rights, it is mandatory that other judicial procedures be exhausted. In relation to the constitutional complaint, I will introduce an interesting case in Korea. There have been cases in which a constitutional complaint is filed on the grounds that a normative act itself violates basic rights. A normative act in this context refers to all kinds of regulations such as law, ordinance, and executive order by president or a minister. Constitutional Court of Korea clarifies that in order for a normative act to become a subject matter in review of a constitutional complaint, restrictions on freedom, imposition of obligation, deprivation of rights or legal status must occur from the content of the normative act itself, before any act of execution by an executive branch. This requirement is called directness. Since legal persons such as corporations can become subjects of basic rights, just like individuals, it can file a constitutional complaint. The state or the local government that exercises governmental power has the duty to protect the citizens' rights and cannot claim a constitutional complaint because it is not a holder of basic rights. A prior review by a chamber consisting of 3 judges is mandatory for constitutional complaints in Korea. Review merits by the full bench won't begin without the satisfaction of the legal requirements. Self-relatedness, being imminent, and directness are needed to meet the legal requirements. If the legal requirements are not met, the claim is supposed to be declared in 30 days from the date of request. Other requirements are regulated in the Constitutional Court Act. There are 8 members of rapporteur judge in charge of prior review. This is a heavy pressure due to the time limit. As shown, in this part is also to be omitted. The rate of dismissal is 84, 74, 81, and 79% annually from 2017 to 2021. About 80% of the cases are rejected by the chamber, consisting of 3 judges. Only 20% can reach the full bench. The fee for constitutional complaint is very controversial. Constitutional Court of Korea is not charging the fee. The problem always becomes a major issue in Korea. Every state has an obligation to protect the basic rights of its citizens. Therefore, from a theoretical point of view, it will be contradictory for a state to claim the code of relief from the citizens whose basic rights have been violated. Imposing the fee over the constitutional complaint may be a reasonable solution to restrain the abuse of it. The Constitutional Court of Korea has a full bench consisting of 9 judges. Furthermore, there are 3 chambers, as mentioned. Each chamber consists of 3 judges. The chamber decides whether the case meets legal requirements or not. These cases that fall short of the requirements will be decided in the chamber. It is desirable in terms of efficiency for our chamber to dismiss a request on review on merits as well as legal requirements. When making the Constitutional Court Act in Kazakhstan, it would be better that the role of the chamber is extended. The decisions of the Constitutional Court are binding over every governmental institution, having erga omnes effect. Therefore, the National Assembly must enact legislation that conforms to the decisions of the Constitutional Court with respect to laws declared unconstitutional. However, forcing such legislative activities is controversial due to the principle of separation of powers. Twice a year, the Constitutional Court of Korea is calling for legislative action by notifying the National Assembly of its decision is declared unconstitutional. When the Constitutional Court of Korea declares all unconstitutional, the decision has ex nunc effect, effective from that on. Only the penalty clause has ex tunc effect, effective from the outset. Let me mention briefly about the communication with the press. Communication with the public is essential. In the case of the Italian Constitutional Court, it is said that judges visit prison facilities to have an interview with inmates. The Constitution of Indonesia holds a hearing every week, and it is said that oral proceedings are broadcast live. Simultaneous interpretation in English is also provided. Since 2013, the Constitutional Court of Korea selected 15 to 20 cases each year and produced a webtoon and posted it on the website. As of July 31 this year, 162 cases were produced as a webtoon. Every year, a webtoon is published as a booklet called Constitutional Court Decisions in Cartoons and distributed to universities and middle and high schools. Such has been also published on the English website since 2018, and 26 items are currently posted. In November 2022, it will show up in the YouTube. The Constitutional Court of Korea had compiled the Constitutional Adjudication Manual consisting of its works. A revised version is expected to be published in 2023. The Public Information Officer of the Constitutional Court distributes press release. In general, the distribution takes place immediately after the ruling. Since the statute loses its effect immediately in case of being declared unconstitutional, press release is distributed after the operative part of the decision is read ASAP. Kazakhstan has amended its constitution and is facing a crucial moment making a Constitutional Court Act. I pay my deep respect to the people of Kazakhstan for performing the task of revising the Constitution amidst difficulties of the pandemic. I consider the dedicated efforts of Chairman of the Constitutional Council of Kazakhstan, Kairat Mami, hosted today's meeting will yield successful fruits. May God's blessings be with Kazakhstan and all participants. Thank you for listening.
Thank you, Mr. P. The experience of the Constitutional Court of North Korea is really important for us. Recently, I visited your trial, your court. Please pay your warm wishes to the entire management and composition of Constitutional Court of Korea. Dear participants of our table, we have heard all the reports. And now I would like to announce the time for the discussion. If you have any questions, please do not hesitate to ask them. If you have any comments, you are welcome to tell them.
I have just Ms. Merkel. Ms. Merkel, the reporter of the draft of the Constitutional Court. Merkel, can you hear us? In the draft, there is a norm formulated. According to that, the Constitutional Court is the body who expresses the supremacy of the law, the rule of law. So, we have a General Secretary Office who is performing the supreme control over the law, including the Constitution. So, is there any collision? Is there any contradiction between the Constitution saying that the rule of law control is for the General Prosecutor Office, for the Constitutional Court at the same time? So, what I mean, yes, we understood your question. So, that is an opportunity to answer. The competency of the prosecutor's office is not supposing the general prosecutor office can react, and now there is an opportunity to apply to the chairman of the council, so no contradictions to the constitutional court, constitutional council. This is the only body that would provide, and it's only for the prosecutor office. So all the laws and normative acts is the competency of the Constitutional Court starting from the next year. Thank you. I asked this question due to the circumstances because the appeals and claims of citizens to the officials in many cases in the initial stage is under the table, staying under the table. And the problem is there any possibility in the Constitutional Court to preview a mechanism to register the appeals and timely registration and loading to the data of the Committee of the Jurisdiction Statistics? Would there be any collision in this case? Regarding the registration in the Committee on Jurisdiction Statistics, it should be additionally discussed, and in general, the mechanism previewed by the draft constitutional law, it's taking into consideration all the world experience. Now, we have got the presentation explaining the situation in Germany, saying that each citizen is subject to go through all the stages of legal defense. And in case he applied to the court, there is already a registration provided, and it doesn't matter for the civil case or criminal case, all the cases are registered. And it required additional discussion regarding registration in the Committee on Jurisdiction Statistics. At the same time, you are thinking about a possible collision and contradiction between two bodies, the Supreme Court and Coalition Council. In the draft law, there is a separation of different missions because the Coalition Council is considering issues of the law. the rule of law regarding the compliance or not compliance without taking into consideration the real circumstances of the case. And thank you. Thank you for the questions. I wanted to add, Mr. Sof, regarding this question, to my point of view, there is a problem because the body of the organizational control and the constitutional council in the future and the prosecutor's office even providing the control, so no collision. If this issue is about the constitutionality of law, anyway, it will be for the Constitutional Court and for the regular courts. And finally, the legal position of changes can be done either by the Court of General Jurisdiction regarding the legal normative acts and the Constitutional Court to decide that. Thank you very much for your clarification. I'm the parliament member, Mr. Kožuchmetov Arman. I'm very thankful to all the speakers for trusting and detailed information. And in Majlis of Parliament, this draft law on the Constitutional Council. We are going to take into consideration international taxes. I have a question to Mr. Ugbekov from Uzbekistan. In your report regarding Uzbekistan, you mentioned implementation that accepting as non-constitutional the law, the Constitutional Court thought one of the consequences could be the revise of the ready-made decisions that were made based on that law. If I understood correctly, you mentioned that. So I have a question. Is initiating the revision of such ready-made decisions, either prosecutor's office, court, or who is to follow such court decisions? Even you mentioned the term 1 month after the decision of Constitutional Court, the judicial system should react to decisions provided before. Could you please give your clarification? Thank you very much. A very interesting question. We still have questions ourselves, theoretical and practical. So let me explain in practice. For instance, there was a recent case that we considered several months ago. There was a complaint from citizens regarding the part of the law that was decided as invalid. So the question was regarding the private assets. So all the cities and towns are changing its facades, and that's why we accepted several documents of the law that are not in compliance to the parts of the law. Some parts of the law were invalid. For instance, in the Constitution it was stipulated that any extension of the private assets from citizens and from legal entities can be done only by law. Means the base stipulated in the law. In other laws, there were collisions and contradictions. For instance, there was the wording saying the legal acts, the legislation, so expand a list of definitions based on which the private assets can be expropriated. So this is a civil code, and also there are several articles in the housing code and the articles of Constitution of the Republic of Uzbekistan. So we stipulated the term 1 month for the parliament who adopted that law. There are two bodies, the legislative chamber and the Senate, and the question regarding the term. So, how to adopt law? During this term, we managed to pass it through the legislative chamber, and the process was very painful while considering this case in the Constitutional Court. It was very difficult because the legislative chamber and Senate contradicted each other, and also the presidential office was involved because the president is having the ultimate signature of everybody, and as the changes are introduced, and we're waiting for the next session, and there is a term in between the sessions, so it was like 1 month, but 1 month was not enough to consider at all. So, when you adopt a new law in the Constitutional Court, it's obligatory to work with the chambers. The Kazakhstan also consists out of 2 chambers, so that's why there should be a process to coordinate that all and increase the term for consideration. Let me clarify. The court expenses. It's a very difficult question. We should think 7 times and adopt it once. Because the court expenses, 90% of appeals are not satisfied, and the majority, according to the procedural basis, we return to citizens. So, in Germany it was mentioned 2% with a satisfaction. In other countries, the proceeding with satisfaction very rarely reach 10% of appeals that were submitted to the Constitutional Court are satisfied. So, our colleague from Southern Korea mentioned that if the law is violating the human rights, so if he is ready to pay to the government on the case against his rights, so it's a collision. So, for instance, there is a state fee to pay, and every time you should look with the return procedure regarding the money paid by government for the state court expenses. Thank you very much for your detailed answer. We hope everybody understood the common words regarding the execution of the Constitutional Court decisions. Yes, there is a big issue. Last year we dedicated a separate round table to that, and the question was dedicated to those particular issues. Any other questions? Let me, Miss Judge, dear colleagues, let me pay your attention and let me pay attention of the working group and the developing body and legislative parliament. The draft of the law contains the procedure of appeal by citizens to the Constitutional Court. After we went to the court of the first level, and after the act coming to force, it is obvious there is a violation of the principle of the execution, that is the doctrinal and academic and conventional principle that was the basis to the court, that have no general jurisdiction like national courts, and also considers the principle of international basis This principle is applied while applying to international courts. For instance, there is a European Court on Human Rights Defense, and the Constitutional Court is a unique one. This is the court on the norm of control, and non-compliance of the principle contains several dispositive consequences, particularly the violation of the general international procedures and just because the overall act that came into force were passed and circumstances stipulated by this legal act is obligatory one for execution. Ignores the mixed court borders and levels is not the fact to accept that the parties of this trial did not agree with the legal normative acts of the national level and vice versa. Everybody agreed with this act according to the national bodies. The principle of exhaustion applied in Constitution is subject to apply. It's obligatory to apply, and I believe that the legal bodies, it's obligatory. The application to all the next level institutional bodies originating the principle of exhaustion, and it could be one reason to apply to the Constitutional Court. And today it was mentioned by a representative of the Constitutional Court of all other countries present here. Thank you very much for your comment. Is there any other questions or comments? Dear participants of the round table, just before our today's round table, all the members of the Constitutional Court explained their ideas in the journal called The Problems of the Law and Economy. The journal is dedicated to the activity of the Constitutional Council, explaining the issues that we discussed today. If you would like to have more information about this journal, dear Sergei Gennadievich, in his library, the library of the State Law University has this journal, and also you have received the copy of this journal, and it was kindly provided by the library to everybody. Thank you, Sergei Khailovich, for your promotion of this journal. And there are practical scientific mentors for all the members of Constitutional Council of the Republic of Kazakhstan and from scientific legal experts. Is there any questions or comments? If there is no questions, according to the agenda, we are completing the planned session. We have very interesting presentations and comments and questions and answers, and after the lunchtime, the table will continue its work in thematic sessions. Let me express my gratitude to all guests and speakers who did their views. And now there is a lunch break for 2:30. See you very soon. Thank you.
Уважаемые гости, у вас...
Dear guests, if you are available, if you are here present in the university, you have a lunch coupon provided for you to have a lunch together with the staff of the Kazakhstan State Law University. Thank you.
Раз, один, два, три. Раз, два. Раз, два. Один, два, три. Раз, два. Один, два, три. Раз. Один, два, три. Один. Раз, два. Раз, два, три, четыре, пять. Один, два, три. Раз, два, три, четыре, пять. Один, два, три. Один, два. Раз, два, три, четыре, пять. Один, два, три, три. Раз, два. У тебя только флоры. А должно в языки сейчас приходить. Раз, два. Не приходит? Раз, два. Один, два, три. Не, я уже пробовал это сделать. Один, два, три. Да, вот когда переводчики не работают, видишь, переводчики сейчас выключены, а в языки не приходит. Только в русский.
Раз, два, три. Раз, два, три. Раз. Я иду только в... Но у меня сейчас в языке ничего приходит. Вот в чем суть. Ни один. Раз, два, три. Раз. Ну, в языке ко мне не приходит. Хотя должно приходить. Сейчас, секунду, подожди, позову этого. Раз, два, три. Уходит к тебе, правильно? Но ко мне в языке это не приходит сейчас. Ноутбук. Раз, два, три. Раз. Раз, два, три. Нет, в наушниках. Но у меня тишина сейчас в наушниках. Я воткнулся в ноутбук казахского перевода. Раз, два, три. Раз, два. Я говорю.
Саш, ты меня вот так сейчас слышишь?
Да, слышу. Это тот сигнал? Вот говорю, я говорю. Да, 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 да. Так, нет, не идет. Нет, не прикалывается. Раз, два, три. Во флор идет, в каналы нет. Раз, два, три. Не может быть. У меня в нулевой идет. Подожди, еще раз. Русский канал. Вот и в русском. Только. Сейчас, видишь, я говорю, все. Вот сейчас приходит. Это было? Раз, раз, два, два. Раз, два. Три. Раз, раз, раз. Да. И если я сюда говорю, а в первый не приходит. Раз, два, раз, раз, два. Раз, два, раз, раз, два. Раз, два, три. Вот сейчас не идет ничего. Раз, два, три. Раз, два, три. Раз, два, три. Раз, два, три. Ничего не идет. Раз, два, три. Раз, два, три. Раз, два, три. Вижу. Казахский вижу. Раз, два, три. В английском вижу. Один, два, три. Эй. Смотри, сейчас в казахском есть название, да? Раз, два, три.
Коллеги,
Все.
Dear colleagues, please proceed to your seats. We shall continue our work within this event, the round table. And now, according to the agenda, we have the second session, which is dedicated to the constitutional judicial proceedings. We all are experienced people, and we understand that the procedural processes, the processes of considering the complaints and claims is very important, and it can be either successful for the whole institution, and it can be a barrier if we are not carefully considering or if we neglect the details. Now I would like to give the floor to the National Human Rights Commissioner in the Republic of Kazakhstan, Elvira Azimova. She will be concerned now with the creation of the whole this infrastructure. Elvira, the floor is yours, please. Good day to everyone. In the first part of the day, you had a very intensive work, and I hope that the second part of the day will be held in the same pace. Indeed, we are concerned about this issue because, in fact, last year the law on the Commission on Human Rights was adopted at the end of the year, and for the first time the law provides for the new authorities of the Commissioner on application to the first instance courts to protect the interests of an undetermined circle of people. In 8 months, we have not applied to that authority yet, but this is not connected to the fact that there are no problems we do have a lot of challenges and problems connected with the imperfectness of the legislative norms and regulations, or with the absence of the uniform understanding of the legislative regulations. And the situation is that mostly the appeals of the citizens we receive, they use the argument referring to the regulations or the constitution, the basic regulations contain not only the human rights and citizens' rights or nationals' rights, but the obligations provided for the institutions of the governments, of the state governments. At the same time, on the part of the state authorities, there is no understanding like this. This is an example. We have discussed recently the questions of the consequences of January events connected with the criminal law of procedure, with the detention procedures. In fact, the events we have seen in those 3 days in the beginning of this year, they set us to take necessary operative measures, not only to prevent similar events in the future, but also on the response in such situations of the emergency state. Unfortunately, it was connected not only with the specific particular issues of high degree of danger, which was at that time, but also it is connected with the facts. Unfortunately, we have to admit it is connected with the imperfectness of the legislative opportunities to react and to prevent. And the practice has shown that, as an example, the access to medical services, access to the legal advisors' assistance to the judicial activities and judges, the issues of detention and using alternative measures of detention or restriction. These are the common issues we have to tackle now. We are working actively now. We really need the support not only from the law enforcement organizations and lawyers, but also the constitutional support is needed. And in this respect, we have a lot of expectations with respect to the set of legislative changes which are planned to be introduced in the first days of September for the Parliament to consider them. Very active work is planned on this package. And before this work, we are applying to the Venice Commission, to OSCE and DIPCH, OSCE and Asian Pacific Forum of the UN, to ask them for their preliminary response with respect to understanding of the human rights at the international level, international standards, and practice available in the other states, and not limited to the constitutional laws on the Commissioner on Human Rights. We also sent draft constitutional law on the Prosecutor's Office and on the Constitutional Court. By all means, creation of the Constitutional Court will strengthen the law enforcement, human rights potential of the Constitution, the right of the Prosecutor General to apply with respect to the matters connected with the regulatory legal acts of the Republic of Kazakhstan for their compliance with the Constitution of the Republic of Kazakhstan. And it is strengthening the potential of the Prosecutor General and Prosecutor's Office as a whole from the point of view of compliance with the legitimacy. And this is a continuation of the process, because it is not enough simply to perform the surveillance and control fulfillment of the obligation, but also to ensure the understanding. Therefore, the work of the Constitutional Court on the acts of the prosecutor is absolutely necessary, and we support this regulation. But at the same time, we have a question connected with the implementation by the Prosecutor's Office of this authority, in particular, the regulations mentioned in the draft constitutional law on the prosecutor's office. Unfortunately, here there are special regulations on preservation of the legitimacy stated in the respect of the government authorities, the right to perform the surveillance of the activity of the government authorities, including the central and local authorities, executive, representative organizations, and perspective of the form of their organizational establishment. And this is clear logically. The regulation is not new. It is available in the existing law. It is similar, but we have a question if the Prosecutor General has the right to apply on the legislative acts and President's acts to the Constitutional Court, because one of the purposes of the appeal is to interpret the legislation, the rules and regulations of the law with respect to their compliance with the Constitution. In this respect, there is no clear understanding in the draft. Another new amendment is connected with the Code of Civil Procedures. This question is still open. More detailed tools for this law implementation, and it does not comply with the expectations of the civil society and human rights organization. Another norm concerns the commissioners' functions. This is a new amendment which determines the right of the commissioner to apply to the Constitutional Court on the issues connected with the compliance to the Constitution on the regulatory acts of the Republic of Kazakhstan. If you talk about the General Prosecutor, the limitations on the content of such requests are not determined. The Commissioner for Human Rights has specific determination of the contents of such appeals. These should be appeals concerning the rights and freedoms of people prescribed in the Constitution. And in this respect, in the draft constitutional law in the Commissioner and in the draft constitutional law on the Constitutional Court, we did not determine the direct, strict regulations to determine the basis for the appeal. We leave this freedom. On the one hand, it is good. On the other hand, I see the experts who say that it has to strictly prescribe the basis for the commissioner to apply to the Constitutional Court, either the personal desire or any specific. It is not reasonable to link it to the particular complaint, because in this case the commissioner should have the connection to the human rights with respect to unlimited number of people, like an authority which appeared for the first time with respect to the ordinance which was adopted in the last year. And accordingly, I think that here determining the basis for appeal is not reasonable. This could be the personal discretion or particular complaints or appeals of the third parties. If you look at practices of the other states which have stated similar authorities and Constitutional Court, while talking to the colleagues, we have identified the idea is that the Ombudsman should not target the goal to win and seek decision from the Constitutional Court or any ordinary court or court of the first instance. The main purpose is to urge the government to review the approaches, and if in favor of the Commissioner, nevertheless should give ground for discussions at the government level. If there is a misunderstanding, no uniform understanding of any rule of law or any act, then it is necessary to take measures to review, to improve and actualize such provisions, and this is the right thing to do. Also, there is another point here. It is connected with the draft constitutional law again, the law on constitutional court and constitutional law on the commissioner. We did not specify in the discussion of drafts presented by the developer, but it was a preliminary expert discussion. In the essence, it was clear that the discussion will start at the parliament level. We didn't discuss the issue connected with the fact when the commission may apply to the constitutional court. The commission should pass the same procedure as individuals, or the commissioner would have the right of direct appeal. The practice of some countries is as follows. There is a right of appeal, excluding the level of appealing after the duration of the first instance court. Right. We think that this is the right decision because, in fact, the institutional commissioner for human rights is not the one replacing the other institutions. It is an additional institution to the prosecutors' authorities, and other authorities should perform their tasks according to the constitution. But since our state at this stage is stating that we would continue the reforming process, and since at this stage we keep on receiving appeals connected mostly in the last 10 years, disagreement with the judgments of the courts and appeals against actions of the law enforcement agencies and illegal ill treatments in the detention facilities. We need to consider those appeals. Maybe in the future this issue will be reviewed, but with this respect, I would like to emphasize that this commission has with a preliminary resolution conclusion. The final conclusion will be provided by the end of September. Of course, we would like to receive much earlier. However, this is determined by the Commission. They can decide on their terms and opportunities. Nevertheless, have answered in their conclusion. First of all, they have noted that the Commission recommends to provide the commissioners or ombudsmen with the possibility to apply to the Constitutional Court of the country to make a decision on the abstract control in terms of constitutional control, resolutions, and general administrative legal, which raise questions concerning the rights and freedoms of the people. Ombudsmen should have the right to do it at their own discretion or based on the complaints of some individuals. The main objective of the ordinary court is to provide for the control. The Constitutional Court fights for control of the constitutional acts. It would be logical for the ombudsman to apply to the Constitutional Court on any cases. Since access to the Constitutional Court through the ombudsman is in that type, it should not replace the main access and should not be considered as additional tool. Therefore, in the context of amendments to the Constitution which were adopted, the priority innovation in terms of the subjects of appeal to the Constitutional Court would be the right of direct appeal of the citizen of the nation. Therefore, this constitutional amendment is considered as a confirmation of the provision on constitutional guarantee and rule of law. Nevertheless, it is necessary to understand that then we should include the indirect tools and mechanisms to support the citizens' preparation of such appeal. Otherwise, the Constitutional Court will be overloaded with all appeals of the citizens. Of course, we are discussing this now, and we all understand what the procedure should be like with respect to the citizens' appeals. Nevertheless, it should not be a actual restriction of this law or of this right. Therefore, I think that we need to be very active in our work in September. This will be the high season for discussions, Majlis and Parliament. During that period, the main skeleton will be formed for the draft laws at the level of the parliament. And of course, in this respect, I would like to note that those people present today and announce us as experts would provide us with their support. Thank you. Thank you very much, Elvira. Very interesting to receive the kind of information like vision and position, congratulations to this high role, and we understand really your high responsibility you have now with this position. We'll get back to this question in the discussion session. I would like to give the floor to Chairman of the Constitutional Court of the Kyrgyz Republic, Mr. Emil Oskanbayev.
Пожалуйста, Эмиль Жолдошевич.
Thank you very much. I decided to change a little bit my speech and presentation. I'm extremely sorry for those who are interpreting, but my changes are due to the previous reports that took place in the first half of the day. On behalf of the Constitutional Court of the Republic, let me congratulate Kazakhstani colleagues and all people of Kazakhstan with the forthcoming day of Constitution. We wish you peace, good health and wealth and prosperity. And let me welcome all the participants of this roundtable, and I would like to thank the organizers for arranging such useful event, and let me thank the committee and the people supporting us in the questions of the rule of law. And the report is split into several theses to make it useful for future development of constitutional control in Kazakhstan. For that, let me share with you the resolution of constitution control in Kyrgyz Republic. That was conditioned by the transformation of our society. And the transformation happened due to the serious tragic events with the human loss. People of Kazakhstan, on the 14th of December 1990, there was a constitutional council formed, and the experts prove that the moments of the constitutional control started to appear in 2013 as a result of the work of this body. As in 2005, in Kyrgyz Republic, there were lots of different serious events, and especially the consequences of 2010. What do I mean? After those events in 2010, by the second decree of the temporary government, and the first decree they used to take the authority on themselves, and the second decree was to abolish the Constitutional Council, saying that Constitutional Council was taking all the power on themselves. And there were changes in the authority system of control in Kyrgyzstan. So I believe that the peace and mind won the place, and there was a different body that was called the Constitutional Chamber of the Constitutional Council. And the activity, they depended on the activity of the higher court, but anyway, the authorities were limited so much that out of the realistic authorities there were norms and control. And before that, there were 10 types of authorities. let me list them. The Constitutional Council gave an opportunity to involve the bodies and make them subject for the criminal responsibility. And they just have left the constitutional control and enabled to a court to become stronger and to get this experience and to investigate and to try this practice. And in the supreme question of constitutional control, the definition of the normative control, regarding the reach of the constitutional council and the system of governmental control. I will speak in thesis. Probably you would not see the direct link in between of my report, but by the end of my report you will understand it. This question seriously discussed before. In general, there was a need when Constitutional Chamber was established to create the body of the constitutional control from the three-branch body and bring it to the state control system with one aim, and it was obvious, in order to decrease the importance of the institution itself and also to decrease, I would say, the executionability of the decisions made by this institution. So it happened repeatedly in the events of the Constitutional Council and control. It's explained also by the basis of Gans Kelvin that was mentioned today. And what do I mean? Speaking about the Constitutional Court should not be relevant to any of the Board of Control. It should be much higher than all other bodies. There could be nothing higher than this Constitution. So, what should be the decision of the Constitutional Court? I believe we have already proved to all the opponents that the decision of the Constitutional Court is a prolongation. This is a continuation of the Constitution itself and cannot be determined just by laws, legal acts, by any documents. This is just a part of Constitution. And that's why in our country, the Constitutional Council is inside the system of the judicial bodies, and it is the supreme body of the principles stipulated of the jurisdiction starts from Constitutional Court. And it seems to me that it's quite useful for our region, especially when we speak about the execution of the Constitutional Court decisions. There were always problems with that. Regarding the Trial Act implementation, they are not subject to any doubts to implement or not, because there is a mechanism of liability for non-execution of the court decision. And based on that, currently, I believe, and we see that, the efficiency of constitutional control is still much higher, because everybody perceives the court decision the way they are not disputable. No other interpretation for that, only directly for execution. Next thing, regarding the constitutional claims of citizens. Here we should strictly understand that there are individual claims, means from individuals, and there is a fight between the governmental institutions and individuals. For instance, a citizen had some expenses or losses, and as the judge from Croatia mentioned today, speaking about the normative constitutional complaint, in 2010, and before 2010, our citizens in Kyrgyzstan, they could not claim to the Constitutional Court, our citizens. And we started to have a definition, the norm, saying that each means everybody, foreigners or local citizens, are in position to argue the constitutional basis if he believes that his constitutional rights and freedoms are violated. Means, together with this definition, we started to have at the same time particular normative control and abstract normative control. Regarding with the exact normative control, we had some issues because a citizen should not bear obligatory some circumstances, and also it's not obligatory he should have some doubts in the norms and constitution. It's good enough to suppose that, and that's why we reviewed and considered many claims and deals where citizens supposed that this or that norm violated his or her constitutional rights and freedoms in particular cases. Recently, we exchanged opinions with colleagues and told my story of the contradiction between the Constitutional Court and the regular courts of general jurisdiction. In our region, usually it happens based on the personal attitude, and I think it's the right thing to do. And we still try to overcome that contradiction. In our lectures, we managed to prove that there is a good tool to redistribute the responsibility. Before, while applying with the claim, in fact, there were no applications, no claim applied. But right now, there are systematic claims on the local courts received. Let me give you an example. When there is a dynamic development of judicial system like in our country, the constitution was changed, the direction of social development changed a lot, and when laws are being adopted, you have to change many things, and laws are changed in packages, 10, 15 laws in one package. So, to be efficient, we try to explain that this judicial system is easier to change by people under the question. We managed to, then they started to apply to us. Recently there was an application from the judges regarding the new in the tax code that enabled to claim to the court, and the fiscal agencies could claim to the court and prohibit the citizens traveling abroad. And after our request, it would be easier for them to make a decision. So same thing with a similar case when government is trying to limit the rights and freedoms of individuals. I'm very interested on time, PT. Regarding the constitutional complaints, around 90% of cases related with the claims from the citizens regarding the normative control. And they try to argue different norms, and at the same time, which way it happens in the courts. First, they go to court because court is going to apply different norms of procedural rules, so they ask to apply to go to the Constitutional Court. Sometimes their requests and claims satisfied, sometimes not. We take 2 months to consider that because it's related to particular circumstances. if court denied, then a citizen or the party is subject to go to the Constitutional Court. And if denied during the proceedings, this is the way it is solved. This is regarding the access to the constitutional jurisdiction. If the General Court denied, then a citizen or a party can apply directly to the Constitutional Court. So, the same recommended before applying to the Constitutional Court, like in other countries, like Kazakhstan and in the world. Also, I would like to clarify regarding the state fees, the trial fees. In Kazakhstan, we considered the issue on the state fee for the court proceedings. Before, it was paid for the claims, financial claims, as soon as the court decision is provided. Before, they had to pay before the court proceedings, and it made 10% out of the financial claim amount. So we made a decision, and we explained why. The state fee has two purposes. The purpose is not to reimburse the expenses of the government spent for the trial, but state fee is to make citizens more cautious about their claims, about their questions, that those questions should be really what they need. And the amount of the state fee at the same time should be differentiated to make no limits to the citizens. For instance, some citizens has no money to apply to the court. So based on that, our government took a well-balanced decree to provide now the state fee, and the state fee does not irritate the citizens in its amount. Thank you very much for your attention. Thank you very much, dear Vladimir, for your brave, sincere, and sober opinion. Yes, we understand this is decided via practice. Yes, you changed points of view, and your experiences process, and we will be back in the discussion regarding sharing the responsibility between the state bodies. And now I would like to pass the floor to our guest from Tajikistan, the chairman of the Constitutional Court of the Republic of Tajikistan, Mr. Akshar Abul Hafiz Abdul. The floor is yours.
Добрый день.
Thank you. Good day, everyone, dear participants around, ladies and gentlemen. Let me, first of all, on behalf of the Constitutional Court of the Republic of Kazakhstan, express my sincere gratitude to the Constitutional Court of the Republic of Kazakhstan and the Venice Commission for the invitation to participate in today's event dedicated to a very important and relevant topic of constitutional proceedings, the evolution of constitutional control in the context of the transformational society and state. Taking this opportunity, I congratulate our colleagues on a significant holiday, the Constitution Day of Kazakhstan, and wish you, Mr. Chairman, and your colleagues all best in your life and your success. It should be known the organization of the events of this kind, where various issues related to the rule of law and the activities of constitutional control are discussed, acquire very important international significance and contribute to the development of this institution. In this regard, today's event, which takes place with the representatives of the Constitutional Courts and the Venice Commission, in a sphere of openness, is proof that the role of Constitutional Court is the guarantee of the stability of the Constitution, the sustainability of the national legal system, and the body that ensures constitutional legality with increase with the year. For a democratic state capable of guaranteeing the rule of law, the most effective legal and guarantee of ensuring the rule of law and strict implementation of the norms of the basic law of the country is the judicial and constitutional control exercised by the body of constitutional control. The existence of an efficient institution of constitutional control is regarded as one of the main criteria by which one can achieve the level of democratization of society as a whole. It is generally recognized that each state creates its own model of constitutional control, taking into account the specifics of its structure. But regardless of this, the very existence of constitutional control is recognized as the most important tool for achieving a balance between international contradictions and the need to maintain a single legal space that arises on the path of the development of a democratic state. In Tajikistan, the creation of an independent judicial body of constitutional control was an objective necessity in the transition period, and the choice of the current model of constitution in the Republic of Tajikistan is determined by the system of state authorities established by the Constitution, the peculiarities of the national legal system, and corresponds to the concept of a democratic state. Based on this, even in the process of developing the first constitution of independent Tajikistan, the question was raised on creating a separate institution of judicial constitutional control, since earlier constitutional control was carried out by the Committee on Constitutional Supervision of the Republic of Tajikistan. Constitutional justice created out in Tajikistan by a specialized judicial board. Constitutional court, adherent to the European model of constitutional control, ensures strict observance of the regime of constitutional legality, compliance of their norms with the Constitution. It should be emphasized that in general, the institution of institutional control has acquired a tendency towards universalization, and it is in the vast majority of modern states. The reasons for which are, first of all, the general recognition of the concept of the rule of law and the development of the idea on the rule of law, in particular its most important constitution. Proceeding from this, it is noted that the implementation of constitutional justice is not only the protection of the constitution, but also its protection in case of detention or establishment of real encroachment, as well as the establishment, maintenance, strengthening, and restoration of constitutional law and order. A text practice of 27 years of activity of the Constitutional Court of Tajikistan shows the implementation of constitutional justice is one of the important institutions of the rule of law state, in which special attention is paid to the supremacy of the Constitution and the rule of law in the country. The effective activity of the body of constitutional control in Tajikistan contributed to the fact that the subject of the appeal became more deeply aware of the importance and necessity of applying this body to ensure the supremacy and direct effect of the norms of the Constitution, as well as to protect them in legitimate interests of citizens. In accordance with Article 89 of the Constitution of Tajikistan, the Constitutional Authority is authorized to determine compliance of laws, normative legal acts, the Parliament, the President, the Government, Supreme Court, Higher Economic Court, and other state and public bodies, as well as the treaties of Tajikistan that have not entered into force since Constitution. Resolution of disputes between state bodies regarding other powers determined by the Constitution and laws. Other powers are also defined by the constitutional law of the Republic of Tajikistan and the Judicial Court of the Republic of Tajikistan, which was adopted on 26 July 2014 in a new edition. The adoption of the new constitutional law on the Constitutional Court of the Republic of Tajikistan was due to the need to take into account modern legislative practice and experience of the activities of constitutional control bodies in different countries of the world. The main goal of the judicial and legal reform in this area is to strengthen the institutional and judicial power, simplify the course of the judicial process, and increase the role of constitutional justice in protecting the rights and freedom of men and citizens, protecting the interests of the state, organization, ensuring legality and justice, and this basis in improving the justice of the judiciary of the Republic of Tajikistan. Dear participants of the round table, according to the powers provided by the Constitution and the constitutional law of the Republic of Tajikistan, on the Constitutional Court of the Republic of Tajikistan, the Constitutional Court of Tajikistan, along with the existing subsequent control, also has the authority to exercise a kind of preventive preliminary control. preliminary control is carried out in relation to draft amendments and additions to the Constitution of Tajikistan draft law, their issues submitted to a national referendum. The Constitutional Court of Tajikistan also, in the course of preliminary control for compliance with the Constitution, checks treaties of Tajikistan that have not entered into legal force. In this case, the agreement is checked for its content and compliance with the Constitution at the moment when it is already signed by Tajikistan, but not yet ratified by Parliament. Of course, here we are talking about treaties that require ratification. If the draft law is recognized as not part of the Constitution, it is not subject to adoption and publication, thereby ensuring constitutional legality, which prevents from the issuance of unconstitutional acts. This is one of the most important functions of the body of constitutional control, which prevents violating constitutional legitimacy before the adoption of the contested normative legal act, in particular until the end of its promulgation procedure. In other words, signing and publishing. Another area of activity of the body of constitutional control, which contributes to the real achievement of certain results in the field of ensuring the supremacy of the Constitution and constitutional legality of the country, is close interaction with public authorities, in particular the legislative and executive authorities. The constitutional law of the Republic of Tajikistan, Constitutional Court of the Republic of Tajikistan, provides for a special form of interaction between the body of judicial constitutional control with the head of state and the highest body of legislative power through the annual sending of messages to them on the state of constitutional legitimacy in the country. This form of interaction is recognized as very positive and is directly related to the rulemaking of the body of the constitutional control. Basically, in messages of the state of constitutional legality, the main legal provisions formulated by the body of constitutional control in the course of its activities are brought to the attention of the legislature, and the national legislature is drawn to the presence of gaps in legal regulation. Thus, not having the right to legislative initiative, the body of constitutional control gets the legal opportunity to participate in the legislative process. Dear friends, it has been proven that the strength of any democratic state lies in justice, and it is in the constitutions of the countries that the main provisions and positions are formulated to ensure law and order in general, the stability of the political system, and the protection of human rights and freedoms. And today, ensuring the supremacy of the Constitution and strengthening constitutional legality can be achieved only by creating favorable conditions for the effective operation of the body of judicial constitutional control. In general, the body of constitutional control, being the most effective tool for achieving legal space, an important factor of stability and a guarantee of the development of society in country, contributes to the strengthening of statehood, the stabilization of social-political relations, the formation of a state of law, as well as civil society. Of course, the presence of the institution of judicial constitutional control in Tajikistan is the only possible condition for ensuring the supremacy of the Constitution, and this institution strengthens the principle of separation of powers, maintaining balance in the system of checks and balances. In particular, the development of constitutional justice increases the mutual responsibility of the authorities for the results of lawmaking decisions they make. Also, thanks to the implementation of the constitutional justice, political problems should be resolved within the framework and on the basis of the law. In this connection, the Constitution, as the main guarantor of the protection of the Constitution, should contribute to the desire of citizens to restore their related rights and ensure constitutional legality of the state. Taking this opportunity, let me once again express my gratitude to our colleagues from the Constitutional Court of Kazakhstan. Thank you for your attention. Thank you very much, Mr. Ashurzoda. Thank you for your report. The next floor will be given to the former president of the Constitutional Court of the Republic of Moldova, chief expert of the Rule of Law program in Kyrgyz Republic, second phase, Alexander Tenasy. Please, Alexander, the floor is yours. Thank you very much.
let me welcome each of you and thank you very much for inviting to the round table dedicated to the evolution of constitutional control in the context of science and state transformation. And let me congratulate all Kazakhstani colleagues and people of Kazakhstan with the anniversary. And right now we have quite an easy situation, and Kazakhstan right now is at the beginning of the development of mechanisms of human rights protection. And last year I had an opportunity to participate, and I'm very happy to participate, to be the expert of Venetian Commission in Kazakhstan to improve the constitutional work in Kazakhstan. The meaning of the project was that in Kazakhstan there will be a constitutional court established in the Republic of Kazakhstan. Definitely this is a very positive step towards to the improve of the mechanisms of the human rights and freedoms defense. And let's make it wider. This is a very important element to improve the balancing system in the government. And it was mentioned a lot, the public discussions to explain the competency and authority of the state authorities. They should take into consideration the principles of authority sharing and to make it efficient. And that's why I believe that the project to establish the constitutional court and to perform the reform in the constitution, it will be a big breakthrough for Kazakhstani people in this area. I would include Kazakhstan into the regional context because the processes are the same in Central Asia. Like Emil Dolshevich mentioned the processes in Kyrgyz Republic. Me particularly, I live in Kiev, in the capital of Kyrgyz Republic, and I had an opportunity to work with the Kyrgyz court colleagues during the reform, and definitely I would say that the results are already there. And in Kyrgyzstan there is an efficient constitutional court, professional court, and during the time since they started to work according to the new law and according to the new format, they bring very brave and efficient decisions that can be provided in Europe. And the same in Uzbekistan. They have a great providing wide competences and opportunities in order to defend the rights and freedoms of citizens, and they have a balance of competences of the state authorities, and this is a very good beginning. And with our colleagues in Tajikistan, we discussed last year as well. They have very positive development as well. So in the regional context, the reform that was just launched in Kazakhstan, it has particular advantages because in Kazakhstan you have an opportunity to analyze other models to eliminate possible mistakes made by others. So let's see the way it works in other jurisdictions. There is no unique way of success. First element that I highlight in this regards is the expectations from the society towards the constitutional court. The expectations can be high, but should never be too high. We should never believe that in a state where not all the borders are working perfectly. We should not expect that one of the borders should work ideally. It's just possible. That's why we're about the access, opening access to the citizens. And let us correct the mistakes and errors. But if we take it too wide, we would have no results. We would overload this body with the claims, and the body will just give some official feedback. This is what our German colleague explained. When the discussion, what kind of access to be provided by citizens to the jurisdiction? First of all, we should analyze the context of a country where we would like to launch it. I had an honor to participate in two such projects. For instance, in Ukraine, when Mr. Poroshenko launched direct access, pity to say it never started to work in Ukraine. And very sad to see that, despite the fact they have all the precursors and all the opportunities to make it work. But in Kazakhstan, it started to work much more efficient, even if it's a surprise. I'll give an example from our colleagues from Litva. This is a country from European Union with a good system of rights, with a well-established democracy, but despite that, as soon as citizens started to have an open access to the jurisdictions, the statistics change. Around 90% of cases they receive from the General Court. Around 90% of cases are filed from the and means that the court has a claim when there is a trial. And 90% of cases are considered for citizens that are participating in the trial. So there is no unique remedy. Let me share our practice in our country and what kind of debates we had in Moldova. Our constitution does not provide direct access to institutional justice. We have the opportunity to conduct it via the trial borders. One of the parties may think or believe that the constitutional norms applied to him in his particular case are relevant to constitution. So he is applying to the judge, and judge is in the position to contact and apply to the constitutional court. This is the way it works in Moldova. What are the advantages? We decided that for our country it would be much more efficient, because if we would provide the direct access for all the citizens, we would overload the constitutional court with absolutely useless complaints. And the constitution would waste lots of resources for filtration and filing, and doesn't mean that there would be some useful decision. Constitutional court is not going to solve all problems of citizens, but they would make the prioritization. We discussed to take into consideration the case applied by lawyers, by advocates, by judges that are contacting constitutional court for some norms. The efficiency of this mechanism, it brings the constitutional court closer to the trial system. So we found an opportunity to introduce the principle of constitution that goes behind the normative act, and to introduce it into the judicial and trial praxis. Before, in Soviet time, the documents were never applied as just an official document. If 15 years ago a judge would to apply a constitution, he would be surprised. But as a result of our reform, all the constitutional principles have migrated from the books, from doctrines, and now we may find tens and hundreds where judges are making the analysis and decisions that are based on the constitutional principles used to develop those provisions in the law. That was the result that what the second effect we got is the depoliticizing of the constitutional court. What does it mean? The constitutional court is the legal body, political body, but depoliticization may happen when the main claimants are deputies and members of the government, ministers of justice, the political figures. And then the agenda of the constitutional court can be formed 100% out of those appeals. And people are not considering the constitutional system dedicated to provide with the human rights and the freedom of defense. And they do not perceive the constitutional court as it is to solve all the problems. For instance, if someone is wanted to a position or removed from his position, so by changing the paradigm into the constitutional court, we change statistics a lot. Before the reform, 99% of the appeals were from the political sphere and were related to the political issues regarding the balance of the power and authorities. And after the reform, we completely changed the statistics. 98% of the claimants are filed from the trial jurisdiction bodies because they are related to the practical aspects for people. For instance, arrest mandate. For instance, according to our constitution, it should be more than 12 months. But usually the saying that the judge can make it longer. So during 25 years, everybody used that norm. No one protested until one judge, after the reform, he started talking himself. How far it's constitutional, saying that in exceptional cases, the Prosecutor General is in position to prolong the term of the mandate. So we considered that and we announced that provision constitutional, and it exceeded all my expectation and imagination. We would not be even able to imagine. In fact, people who was detained in the preliminary detention unit for 3 years due to no reason, and after those changes they were released from the detention unit. So we had depopulation. We freed all the inmates who were the detention unit. So right now this practice is similar everywhere, and in the decisions of the courts we stipulated that it's non-constitutional, and we announced that a person is subject to arrest only in those cases if he is escaped from the investigation borders. And even the criminal charge and the criminal case is not the reason for the longer arrest, for the detention. And we stipulated all the mechanisms, and the result that in 19% of the detention is 30 days, the second detention maximum 2 months, but we have inmates in the pre-detention unit more than 2 months, more than half a year. Of course, the prosecutors were against, because they used this tool in order to make the bullying, to push the people, and most of the time they were people who were guilty. In such cases, the general jurisdiction is not to argue of the constitutional decisions. Another example. The problem in the ex-Soviet states, even there is an administrative fine, administrative case, there is some that is enabling judge to change it. For instance, a fine, administrative fine of 100,000 euro. So there could be different violation. Probably there is a basis to put 3 or maybe 1,000 euro fine. So it was regarding the civil code, administrative code, and criminal code, saying that judges should always have an opportunity to customize the fine. So we have taken away the limits. So people understood why it may happen, because they could be distinct from the Great Constitutional Court and the issues of the Greek opinion. The system is not, judicial system is not very popular in Moldova. There is a trust, but the Constitutional Court has 90% of trust from citizens, and people felt that the Constitutional Court decisions have been able to improve the mechanisms in proceedings. So I have already provided the details in the written form to you, and we discussed that before. Regarding the procedure of the appropriate proceedings, should be no limits, should be allowing principle. Could be some technical aspects stipulated. And there are 4 main elements checked in jurisdiction. First, the judge is checking if this law is applied in this particular case, and if the law can impact the person applying. Secondly, the judge is checking was there any other court decision. In any case, this is a very flexible law, because the decisions can be different for the same problem from different point of view. Point number 3, judges are to check according to the special form that was developed by the Constitutional Court, that the citizen should go through the list and work according to the list. We worked together with the European Union regarding that. Point number 4, the Constitution can never be annulled just in case the formalities were performed not in compliance. So the court personnel is checking that, and they can accept it for consideration, and there will be no denial. And let me share my experience, which way we have made this institution attractive for the public, and after that the Constitutional Court started to work better. There was a discrimination. So let's take it other way. If we had an opportunity to go further in order to show to the party that we have listened carefully, the party would do it. For the Constitutional Court, there would be an opportunity to accept norms as non-constitutional. We did that always for the parties to see that this institution works. And if, for instance, we would use the limiting method, for instance, denying everything, declining everything, but we should provide explanation why citizen case is denied or declined. Even a person lost the court proceedings, he should have feeling that there is justice. Then we would have a real trust to the institution. Let me summarize, because I'm limited on time. I would like also to give an opportunity to Mr. Vardaman to speak out. And to finalize today, there were many things said, and there is an expression, and it was mentioned Hans Helsen and his expression, saying that constitution without without constitutional council, it's like a sun that is shining but not warming you up. Means the constitution without the capable constitutional court is exactly the case where you have the sun shining but not warming you up. So I'd like to see the sun warming them up. So let me wish good success to the colleagues from Kazakhstan, to have good luck, to have an understanding of the processes and support of this process, because everything we do in favor of human beings and society to defend their human rights and freedoms. Thank you very much for your attention.
Thank you very much, Alexander, for your speech. We didn't want to interrupt you and to remind you of the time, because it was a very interesting description of the point of view of the person who is dealing with the constitutional justice. I think we'll get back to you, I'm sure, because we might have questions to you within the Q&A session. Thank you very much for your assistance. We will make our sun warming us up too. I would like to give the floor to the chairman of the Permanent Commission on the State and Legal Issues of the National Meeting of the Republic of Armenia, Mr. Vladimir Vardanyan. The floor is yours. Thank you very much, dear colleagues, dear friends. Once again, on my own behalf, I would like to congratulate you all the upcoming holidays, the Constitution Day of the Republic of Kazakhstan, and taking this opportunity that my colleagues have changed their reports. I have made some changes in my report as well, since there are some aspects to pay attention to. It would be good to have the Constitution not writing the articles announced orally, but also to discuss the aspects to be discussed verbally, orally, and bring us. I think it was today morning and yesterday I felt there is this discussion with respect to the case of the Constitutional Court in the system of governmental authority, and yesterday in the Legal Academy, and today here we are talking about the status of the as a part of the judicial system, not a part of the judicial system, how it should be included into the whole system, and so on. I will be a little bit provocative today. I would like to say that this discussion has, in my opinion, a theoretical and a little bit artificial nature, because we are talking about presence of some functions. Yes, indeed, the Constitution prescribes for the functions, which is to ensure that any document from the Constitution should comply with the Constitution. Function is there. We can call it the Constitutional Council, Constitutional Court. In Armenia, when we were creating a Constitutional Court in 1995, when the Constitution was adopted, it was called Constitutional Court, but in its properties, it was more council, not a court. When we talk about the role and place of the Constitutional Courts, we need to think of the functions. If the functions are there, then they should be performed. And here there is a principle of separation of the powers, which occurred much earlier than the majority of the government authorities which exist today. By the way, what is the place of the prosecutor's office? There is a long time dispute about that, and what to do with the institution, to the ombudsman and human rights commission, initially the parliamentarian body, the central. It has a constitutional status. What does it mean? And how does it come within the system of the authority as it is? For example, in the Western democracy, they have no questions like this at all, as I see it, because they have theoretical, not applied nature. I'm talking about system where we don't understand, where parliamentarism stops, and where strict separation of the political and apolitical powers is divided. However, what is a constitutional court? It is a unique body. It includes the nature, the features of this judicial body, whether we like it or not. The justice is checked with respect to control of the regulatory provisions, and it has the legislative function, whether we like it or not. At least it is not persists in the ethics. It has no theory of negative legislation, but still the courts perform this function. We cannot avoid that. As the parliamentarian, I can not name any act adopted by the parliament as a law, because at any point of time the Constitutional Court will make another decision to change that. Therefore, they have some specific functions. Nevertheless, in the parliamentarian countries where they have no two-chamber parliament, the presence of Constitutional Court with significant authorities is an opportunity to restrict the limits of the balance between branches of the authority. Today, we would like to discuss the main topic of today's session, which is dedicated to the judicial procedure, to the process. There are different models. Every state has its own judicial models. They are absolutely different. And as a person with quite an intensive experience working at the Constitutional Court, I would say the most difficult times for the Constitutional Court is when, as a result of the constitutional and legislative change, range of subjects the right to apply to the Constitutional Court is increasing. Here, the serious problems relate to the management of work of the Constitutional Court. Why I'm reminding you of these problems? Because yesterday, with my colleagues from the Constitutional Court, the Republic of Kazakhstan discussed it, and we found out that we have a very limited number of personnel, consisting of 20 to 30 people. About the authorities available in the draft law, then it would be difficult to avoid serious management and difficulties. This is not expanded early before the authorities come into effect, because the effect of the funeral will increase, and many states use different methods in the constitutional courts to decrease the number of cases. Nevertheless, no matter what we say about the necessity to create a particular opportunities for the objective work of the Constitutional Court, our institutional structural model of the Constitutional Court should comply with the models they have. The presence of a big composition of the court will not solve all the problems, because if the court will have a low capacity and the administration will send more cases than the court may consider, this will cause serious problems. We face this problem in 2005, when the authorities of the Constitutional Court to individual complaints. I would like to warn you, as soon as you involve the institute of individual complaints, the Constitutional Court will overload it with cases immediately. It is an absolute urgent reaction, because the people will try to search for salvage and justice at the Constitutional Court. More than 99% of the cases would be denied, because most obviously we will concern more not the constitutional aspects of the law applied to some people, but so they will relate to the search of the justice by the people. I would call it a 4-year period. It will become the period of disappointments, and then you will have much less cases, and the filtration agencies and the big number of personnel will be required. And only after that, step by step, when the normal law enforcement practice of constitutional practice will be performed, the flow of the cases will be observed, those which are legitimately acceptable for the Constitutional Court. Another important element I would like to discuss today, I think it is very important in this respect, is inclusion of the interstate remedies, because knowing our lawyers, attorneys, full bulk of cases received by the Constitutional Court with the filtration mechanism would receive much more than they would be capable to deal with. Why it is important? It's important because in many cases an individual at the Constitutional Court, with the rare exception, is looking for the justice and legitimacy. And the judicial system should have an opportunity to solve the question with seeking for justice before people apply to the court. But really, the Constitutional Courts had the cases controlled when there was a situation when regulation, not application of the regulation, but the regulation itself did not comply with the Constitution, or there was some context of unconstitutional status. We have discussed a lot and quite a long about the duties, if it should be applied or should not be applied. We have very low duty paid in our country. It should be discussed why the duty need, what for. We have identified that in order to increase the state budget, $10 is spent by the judicial system. It is spending in total about $150 to $200. So what the duty should be like and for, to comply with the traditions, not clear, or if it is a duty, it must be high to cover some judicial expenses. It cannot be high because it is violating some other rights. In this case, what should it be like, or will be more pragmatic in solving this question? Especially constitutional justice, a person even within the framework of the so-called regulatory control, it is protecting not only himself but the others as well. And if it is not constitutional regulation, it will relate to everything. If you don't mind, I will briefly talk about the issue connected with the influence of COVID-19 on the activities of the judicial bodies, including constitutional courts. It has a very important influence from the point of view of the procedure and material part. What is COVID? COVID tried so abstractly to affect the human rights and judicial difference. I remember the situation when the prosecutors and lawyers were supporting transfer of any case to the other formats, especially when everybody was afraid of everything with the FRA, and the COVID situation forced us to change some classic forms of the judicial procedure and communication. Until now, we have some deficiencies thereof, and I think that we need to think of how to provide for efficient remote, maybe not remote, but alternative measures to be able in such situations like COVID, which may be connected with some other outbreaks, how it would influence the judicial system. Here I need to ask a provocating question, whether it is done sometimes to avoid direct contact with the parties and opportunity to work in a normal course of work. Because COVID-19 and other pandemics which may occur in the future, they should not, they will not be considered as something canceling the rule of law, like something limiting or restricting the freedom, which could change the democracy structure itself. We need to think altogether about this, what we could do to provide access to the justice and protection and defense of other constitutional values. Also, I cannot help discussing the Constitutional Court future in case of individual complaint introduction. If we are fair enough after the individual complaint becoming a part of the activity of the Constitutional Court, the Constitutional Court turns into a not Constitutional Court but the Human Rights Court, whether we like it or not. In the European Council countries, quite frequently the Constitutional Court, considering such issues, it is mimicking and behaving as European Human Rights Court, because when a citizen within the framework of a regulatory control provides some complaint to the Constitutional Court, it is considered as an opportunity not to solve unconstitutional status of any law, but also they are considering this process as a possibility to protect the rights stated in the Constitution. From this point of view, there is a question, maybe in the individual complaint, maybe we should not include any limitation of remedies. Maybe we can limit it to the regulation on the human rights. That would be an interesting approach, but many questions related to the human rights, they indirectly are connected with the articles, like Article number 1, concerning the regulations of the legal state, legitimate state, because in the normal, ordinary constitutional courts, they count the judgments related to the human rights. I am abusing your time. Sorry, I have only 1 minute and 90 seconds of delay. I will stop my provoking discussion. Thank you very much for your attention. I will be happy to answer all your questions. Thank you very much.
На самом деле, Владимир Владимирович, вы...
In fact, you started organically well the discussion session. You started to explain the issues that we have not started to discuss yet. So I kindly invite you to participate in the discussion. Do you have any questions or comments? I have not a question, but a question and answer at the same time. In the draft of the constitutional law to establish the Constitutional Council and principles formulated, but pity to say, in the system, in those principles, it's not stipulated the two important principles formulated in 2011, the approved by decree of the President, the concept proving the principle of efficiency and neutrocracy. Regarding the efficiency of constitutional jurisdiction, we have the chairman, Sergei Gennadievich, who explained well the meaning of the principle of the justice, and we can explain, basing on that, the principle of the efficient jurisdiction. The second issue is meritocracy. This term is meritus is about the person who deserves the power, the authority. In the Constitutional Court law, it is stipulated that the case for the position of the constitutional judge should come along with those principles. Secondly, it is related to the problem of efficiency and improving the law for the human rights defense. Particularly, Miss Elvira Belkhasimova are aware well about this problem. First of all, it's related to the human trafficking and exploitation. To say in our legislation till now there was no reflection of those problems. So there is no article, no charge for exploitation, for using the people, the labor of people. There is some article for trafficking, for people trafficking, but with gaps. And those crimes are regular crimes. So this is your question. My question is, the developers of the law drafts on constitutional court and the legislation to improve the liability for human trafficking and human exploitation, to be focused on that. The question is which way they would like to resolve those problems while developing those laws. In the Constitutional Court and in the legislation, stipulating the liability for the human trafficking, and I'm asking Ms. Merkel and Ms. Elvira Belkhasimova regarding the human labor exploitation. Regarding the principles of meritocracy stipulated in the documents, it's not directly stipulated, but the meaning of this is available there. We're not speaking about ethics, we're speaking about the article explaining the requirements to the chairman and to the judge. It's necessary to have particular experience and to have authority and reputation in the community. This is the principle of the meritocracy. So no question about that. Regarding the principle of efficiency, what do you mean by that? Does it mean the efficiency of the Constitutional Council operation? Or what should be the basis for the Constitutional Court? The principle of the efficiency, to our point of view, it should never be directly stipulated. The law should be efficient. And many speakers of today explained the exhaustion, and this principle is not stipulated yet. And even in the depletion, in the exhaustion, it's not there, and it's in accordance with the international practice. And regarding the principle of the efficiency in all the countries, like Germany, representative mentioned, 90% of claims goes back, and other country, Croatia mentioned, and Kazakhstan mentioned that 90% of claims from citizens are denied because they are not in compliance with the requirements for the companies. So the principle of efficiency should not be included into the activity of the Constitutional Court, but in the law itself. So now, if it remains the way it is, you should establish the second Supreme Court, and the judges would not be able to do all that work, and the expenses are on the state budget. And let's take the exhaustion principle, and the money left we would send to the orphaned houses. Regarding the second question regarding human trafficking, this is a very specific question, and nevertheless, from the point of view of human rights protection, to be discussed. So in the Ministry of Internal Affairs, within the frames of governmental plan for the human rights protection, it is loaded on the website, and it is called the eradication of human trafficking. And despite the criminal charge for the human trafficking and for the exploitation as well, and we are discussing how the definition, and in general the developers of the law, they're against to perceive the criminal like that. So that's why I think if you have your suggestions, it's better to join the working group. This working group is arranged by the Ministry of Internal Affairs. According to the governmental agenda, the term to submit it to the government at the first half of the year 2023. So you have an opportunity to give your suggestion. Thank you. Yes, they are very specific and narrow, specialized spheres, and there are other problems as well. It will be next stage, I think. I have one question. I have a request to make a short comment, Alexandra, because you mentioned that you managed to incorporate and perform the migration of doctrines and principles into the trial practice. And I could say that it would also be to Kazakhstan in case we would teach and train the judges of the Supreme Court and the courts of the criminal cases, administrative cases, how to use the direct force of our law. Would it bring any impact that would overcome the effect from the administrative justice? Because currently administrative justice is the flagman to satisfy the needs of citizens looking for the fair solutions against the power and authorities. Am I correct? Yes, definitely. I'm sure it would impact possibly all the jurisdiction system, and you know perfectly that in fact the administrative law is just detailing of the constitutional law. This is same thing, and of course it would help a lot to the administrative law as well. I worked with judges for administrative law in contexts of different things, and I saw they implement that they knew the provisions of law, but they never knew what is that for, and constitutional law will enable them to understand better the fundamental principles. It would improve in better quality the justice procedures. Thank you. May I ask? Yes. Dear Mr. Nasser, out of the report, 90% of appeals are filed from courts according to your legislation in Moldova. While considering the cases, if a party is asking the Constitutional Court the constitutionality if it conforms with the Constitution according to your law. Does it happen depending on the decision of the judge send it to the Constitutional Court, or the judge, without him considering, he should forward it, this case, to the Constitutional Court? And the second question, the claims, 90% of claims means from all types of the court levels or the first level courts. Regarding the liabilities of the judges, according to the decree of the Constitutional Court, all the courts without any claims, in case there are doubts regarding the constitutionality, claims should be redirected and forwarded to the Constitutional Court. The same thing like ratione persona, ratione materia, the European Court is implementing. So if it's subject to the constitutional trial. Regarding the statistics, we have limited statistics when judges would refuse to forward it to the Constitutional Court, but just in case, we obliged the Parliament, and Parliament introduced into the legislation the possibility to protest the situation when the judge does not forward automatically to the Constitutional Court. Usually there are courts of the first jurisdiction, the first instance courts, because, for instance, the Supreme Court mainly applies there for fundamental issues. For instance, there are leftovers of the Soviet Constitution. For instance, the decisions of the plenum of the Supreme Court. So we informed they are not obligatory to implement, and judge can act and may act according to his internal values, and they have a kind of recommendation, and after that they edited a press release and loaded on the website and informed judges, saying that judges have no right to refer to the decision of the plenum of the Supreme Court before made. So we annihilated the leftovers of the Soviet system. This is regarding the Supreme Court. Regarding the procedural detail, it's mainly for the courts of the first instance, and the judges felt already this tool that it's really useful to eliminate the cassation. So it's easier to contact Constitutional Court. They would provide a final response to interpret different norms of law. I would like to express my point of opinion regarding the reports of the different participants. Regarding the first issue, what is the status of our Constitutional Court? Out of the previous description, still it means the quasi-trial body. Why? Because we're used to, and we believe that for the justice body, it's typical to have the procedural precision and detailed stipulation in legislation, subject that it is stipulated there by the court law. There is dependence on the law, and it's stipulated anyway. Secondly, I would support the speakers I think the amendments to the Constitution regarding provision the access to the citizens to contact directly the Constitutional Court, it goes along with the changes in the administrative justice. We mainly used, take into account the Soviet heritage, if there are some norms in the code, so they are reflected in the norms. The direct action of the principles we see for the first time as a result and implementation of the administrative legal principles. Some principles are taken from different industries. So if you are a specialist in the administrative justice, you are aware about that. So what I wanted to say, if we are saying that it's done along with principles of administrative justice, and if the bodies are bringing their face to the citizens, turn their faces to the citizens, so there should be a reflection, and I'm sharing the issues and the questions that were asked. It's important to determine the amount of the state fee for the court proceedings. Secondly, it was mentioned that in many constitutional courts there were too many claims from citizens. We should never be afraid of that, but another thing, we may lose the trust from citizens, and they may lose the trust into the law and to the constitutional court, and I'm sure it's important. And from that point of view, I'm sharing the point of view. Yes, probably we may increase the office, but we should be able to work with that. We are limited on time. Sorry for taking my, but important to say. According to Article 78 of the Constitution, the courts are obliged to stop the proceedings and the Constitutional Court in those cases when the non-legal act is violating the constitutional rights of a human being. In other cases, regarding the human rights regarding the citizen, we're speaking about his rights that touched upon. It's not able to violate, but probably his rights are somehow touched upon. So still we are having the representatives of the Constitutional Council, and like we announced before, in any doubts we should apply. Thank you much. I'm sure this is the way it will. And I would suggest to share the latest comment in between of two speakers, and after that there will be a coffee break. And after the coffee break we're going to have the final session. I have a short question to Ms. Elvira Hasimovna. When you made your report, we pay attention to this distance is to the Institute of Advocacy. As statements were said by other two speakers. So my question is simple. This institution was never allowed as a subject to apply. It was not supposed to be a part of Constitutional Council, but now we're speaking about the Constitutional Court. What is your opinion? Probably we should think that on behalf of the Republican advocacy, they should be rights to give it to contact. Why? Probably more than others meeting the infringement of citizen rights. In my report, I mentioned that I would like them to render such services, but currently there is no mechanism like that. And when I hear from one of the members of the advocate chamber saying that it's very unhygienic, I have some doubts, because in our practice we see that some advocates are chasing for money, not to defend the clients. So it's important to have a clear basis. This is exactly what you did. It's allowed the Republican chamber to develop those mechanisms. And when Constitutional Court would start to work, which should have in parallel the work to reinforce the advocacy community. When the personality of advocate should be personalized in the process, because if not, we can come to the impasse. Ashad Dolbaev, my name is, and regarding the report of Mr. Alexander Tenassi, I have one remark and one question. First, let me highlight the Constitutional Council during 3 years applied to government, to the judicial system, indicating the question that the application of the parties should be the basis to apply to the Constitutional Council. The way it works in Moldova, without any constitutional reforms, without establishing constitutional court, we would come to the model already, just making additions to the subjects of application. And also this is what we were discussing during several years regarding the commissioner and the prosecutor. We suggested to provide them that authority. So all that came from the Constitutional Council, and twice it was mentioned in the address from the Constitutional Council. Pity to say neither of the judicial systems reacted. So 9% of the appeals, either it's short-handed sightseeing in the defense of the human rights or in the assessment of the constitutionality of those acts. And also there was a question the overload of work. You are saying we should never be afraid to be overloaded with appeals and claims. I think we should take that seriously. In case the Constitutional Court would be overloaded, then, as you may know, if there is a concentration of cases instead of tens, it would be thousands, then we cannot speak out quality in the preparation, consideration, and motivated decisions. And when our colleague from Moldova said that overload disappeared somehow, I'm afraid that case would not have the legislative barriers. For instance, if there is the exhaustion and all the other trial procedures. So if we would not make any legal barriers, we would be overloaded, and I have doubts it would disappear. You may see their overload during 5 years on other bodies. They may spend 5 years before they start the consideration of the cases. It just goes into the table. So the trust to such system may decrease quickly. So it's not a question, it's a remark. Thank you very much. I hope everybody expressed your point of view. We'll have a break, and in 10 minutes please be back. Okay.
Dear guests, dear participants, thank you for your attention, for your participation. We are happy to welcome you in the new building of our university. I'm happy to be a moderator of this round table. I would like to say thank you to the chairman of the Educational Council, Mr. Mami, for the trust and confidence. You see how much our university has changed. We have School of Law and Public Administration being actively developed in our university. That is why it is important for us to participate discussion of the constitutional control. The topic of our session today is execution of the decisions of the constitutional control bodies. It is a very important topic because one thing is when the constitutional control bodies make the decisions, another thing how they are executed. Efficiency of the authorities of the institutional control depends on the quality of execution of those decisions. I would like to express my gratitude to the Constitutional Council for the trust to be a moderator of this session. Today, our first speaker will be Vice Minister of Justice of the Republic of Kazakhstan, Mukanova Amratovna. Please, the floor is yours. Good day, dear participants of the round table. Congratulations to the upcoming Constitution Day. Dear members and participants of the round table, this session is devoted to the execution of decisions of the constitutional control bodies. Activities of constitutional control bodies are aimed at ensuring the supremacy of the basic law. This mission presents the importance of the decisions of the bodies of constitutional control, implementation of which is an indispensable condition for the establishment of the rule of law. And the execution of decisions of constitutional control bodies is a necessary and important condition for the proper functioning of state bodies and the establishment of a constitutional state. When reacting to decisions of the bodies of the constitutional control, legal rather than political factors should become decisive, especially if they provide for specific obligations for the subjects. Therefore, there is no doubt that the legal nature of purpose of the decisions of the bodies of constitutional control require not only their execution but also the establishment by law of a number of legal guarantees for the execution. Issues of execution of decisions, the constitutional bodies are of importance for Kazakhstan in the light of the reform currently being implemented. The Constitutional Court. As you know, the initiative to establish the Constitutional Court was outlined by the head of a state in a message to the people in March this year. Following the results of the Republican referendum, amendments were made to the Constitution, which now brings the state of the Constitutional Court. If we consider the decisions of the Constitutional Court, ensuring the constitutional rights and freedoms of the human beings, these acts should be cancelled, should not be applied from the time of adoption of the constitutional decision by the Constitutional Court. The Constitutional Court will not only state the constitutional status of the legal announce them null void by its decision. Also, the constitutional level, the power of the decisions is prescribed. The Ministry of Justice, together with the Constitutional Council, have developed relevant draft constitutional laws on the Constitutional Court of Kazakhstan and bylaws, and they were aimed at digitalization of the above regulations. Thus, the draft constitutional law provided for consideration to the Parliament of the Republic of Kazakhstan the following main mechanisms of execution of Constitutional Court decision are provided for. The obligatory status of the constitutional decisions, the court states that the issues should be in effect directly and do not require any confirmation by the other constitutional bodies. In our opinion, these regulations will help to interpret that the regulatory acts and their parts, which are recognized unconstitutional, will lose their force after adoption of the relevant decision and without any additional formality. Besides, the draft provides for consideration of recognition of constitutional some provisions cannot be considered a repeated adoption of the same regulations. This is quite a wide formulation specifying the nature. It is quite important to use them because it will prevent from the cases when the non-execution of the judicial decisions would prevent from non-admission of the judgments which were recognized as unconstitutional. Also, other regulatory legal acts may be invalidated on the same provisions or repeating same provisions. Here we talk about the building of the uniform system of law, and that's all incompliances should be eliminated accordingly. At the same time, the government authorities and officials must inform of the measures taken to execute the Constitutional Court judgments on decisions. Here I would like to, in the presence of the Constitutional Council and existing experts, to determine the existing practice when the state authorities do not always promptly perform the recommendations and instructions described in the decisions and messages of the Constitutional Council. The recommendations in the constitutional decisions related to improvement of the legislation should be considered by the government authorities and officials with the obligatory information of the Constitutional Court of decision made. If the decision to adoption of the legislative and other measures on elimination of the gaps in the regulatory acts, 6 months are provided for the authorized body to make relevant changes in the respective law and adopt the respective regulated legal acts. In 2021, the regulations were brought into the law on the legal acts, which provides for simplified procedure for preparation of the regulatory acts with respect to the constitutional control. And this regulation will have most importance for the Constitutional Court decisions. We understand that the important role will be played by the text of the constitutional procedure, which will be starting from 2023. And of course, the question of sensibility and efficiency of activities of the governmental authorities will be considered. Thank you very much for your attention. Here I finish my report. Thank you very much for this interesting, very interesting measure you have mentioned, and the boundaries also applicable to the efficiency of execution bodies of the constitutional control. Georgi Popoashvili, former Chair of the Constitutional Court and former Minister of Justice of Georgia, expert of the Venice Commission. Thank you very much. I would like to welcome all our colleagues and friends in person and online. You have provided your public speech and reports. Due to pandemic, we had no chance to visit you, but we had a chance to get acquainted with another competition. Now we have a healthy competition, but step by step we will approach you. The next meeting we will have in Nur Sultan in person, I hope. And once again, I would like to congratulate you all to the Constitution Day, because in the last 12 years I'm happy to visit this country these days for this traditional conference arranged by the Constitutional Council. There was a little break due to the pandemic, and now we continue this tradition. It would be interesting in 1 year would be I invited for the sake of conference, if we blame the Constitutional Court or we will cheer it, what will be the first steps of the Constitutional Court. This court is not created from the zero, because the Constitutional Court existed historically. We will not name the names, call the names of the ex-judges of the Constitutional Courts, And now the Constitutional Council has partially the authorities of the court. So this is not the start from zero. We don't need to start from scratch, no need to cry, not to need to cry that we'll have a lot of things to do. Nowadays we have a lot of cases to consider. Everything will be good, will be fun. There are a lot of people working in Constitutional Court in Georgia. They went to the Black Sea to calm down a little bit, to relax, because we have a lot of cases. If we had no individual complaints, we would have nothing to do. I think then we will have no salaries, because parliamentaries, they are a little bit lazy. They don't want to write the complaints. The complaints are needed for the political issues to be solved, and the judges, they are slow, but it takes a long time for them to think. They need several months or years to make decisions, but parliamentarians cannot wait for years. Maybe parliament will not exist in years. So they need to take care urgently of some issues. So the government will not say anything about the government. Ombudsman is very active. So our main objective was not the political organization, but individuals who cannot write in high quality their complaints. The ombudsman are helping, the political parties help them. The first ombudsman, when he started his work, they started the tradition to write the complaints. So they started to compare I'm talking about the ombudsman, not about the president. I'm saying good things, nothing bad actually. Don't think I'm not talking about the president of the university. What I mean, it's that you are talking about the challenges, and our colleagues from other organizations help us to solve them. There would be, in order to have no technical problems, which will become global problems. If you have any barriers, don't worry, I will proceed to the topic of our discussion now in a moment. So if there is a problem of exhausting in the ordinary courts, I don't know the realities on the side. We need to ask to have enough judges to be appointed, to increase the administration 3 times, and then they will have no cases. This will not be the case. We will have more conferences, more round tables. We will find something to do. If we proceed to our topic, I know it's quite late, close to the evening. Those who stay here, they're stronger. I will not abuse your time. I will try to be short. My presentation, my speech was in English. If I check the modern technologies for translation, I will check my Russian translation is good, and I will practice my Russian to improve it. So, as for the decisions of the Constitutional Court, we have solved all the problems. Now only decisions remain to be considered. The court is working. There is only one problem, is to perform to make the decisions and to execute them. The experience of Georgia in the international context may be useful for you and interesting for you, because Ms. Minister of Justice has already specified the trends for the Kazakhstani way for the decisions execution. The draft law is being discussed now, and we hope at the international level, maybe it will even reach Venice if the discussions will continue on site. So I hope that we will have enough opportunities to work on additional on the process. The constitutional procedures are standard. The decisions of the Constitutional Court are final. The decision is made. In our case, what should be done? How technically this problem is? This is all sent to the parliament, and this part of the decision from the general part of the law. It says that there is this date, this number of the decision, and then negative legislature is doing like this, but nothing is working like this. For example, we have a practice, and the legislation made it possible for us not to not to execute the court decision, but to suspended a little bit. It was not provided for by the Constitution previously. It was the law and practice of the Constitutional Court, but everybody was silent because it was a forced measure. Nobody could change it, and especially in the criminal cases. If the constitutional law is provided with the legitimacy, it works no longer. What will happen? This existed, and then later, in several years, the constitution was changed a little bit. As for the Ministry Commission in 2016 on the draft law for the constitutional law of the Ukraine Ministry Commission supported the opportunity for postponement, especially for the criminal cases, which could result in immediate remission of the accused people. So the facts should be taken into account that they apply the law which was recognized as unconstitutional. In the beginning, we had a practice before we came to the court. I came and younger experts came. I will not say how old we were at that time. They were practice that our previous judges were writing recommendations for the articles and for the decisions. The legislation should be excellent, and the parliament should take it into account, or something should be changed in an abstract way. This practice was abolished because nobody was following that, nobody was reading the recommendations. It's good to have the motivational part and resolution part in the articles so that they are immediately executed and implemented. Maybe this is the case in Kazakhstan. This is just a friendly recommendation from my side. Now, an interesting theoretical issue: the influence of the Constitutional Court acts on different branches of law in Georgia. There is no approach. Like if we talk about the criminal law, the cases may be opened in the criminal law. It was not clear in the administrative case. There was an international practice to restart the case, but in the civil cases, in the beginning, was even if the law is abolished, the constitutional cases were not started, and there was a complaint about that to the Constitutional Court that on the civil cases, a person should satisfy the rights of this person concerning the civil law. It is quite a difficult question, and the Constitutional Court was thinking for 2 years. I was not there anymore. I'm just informing you, and then they sent an inquiry to the Venice Commission. It is good practice. I recommend you in the future to the future Constitutional Court of Kazakhstan to use this opportunity to apply to the Venice Commission. If there is a difficult question, you can apply to them, send an inquiry to ask for their opinion. It is not obligatory to fulfill their opinion, but sometimes the situation make the decisions. Based on the request of the court, the Commission replied that one of the characteristics of the legitimate state is defense with the human rights laws and provisions, and it is necessary to ensure efficiency of the mechanism of the constitutional control. It is necessary to find a balance between the individual protection and defense on one hand and legal determination. And the concepts, as you all know, when the act was adopted, the act of and an unconstitutional basis when it took me several years to understand the difference between Extung and Extung when you do it from this side and when you do it from that side. Court has a question to determine specific criteria and if it could be implemented in the reality in terms of rule of constitution, and if they're just enough. In some countries there is an action of the Constitutional Court by Extung. The legal system gives the opportunity to use extunct. In this case, it will mean that the unconstitutional provisions will clarify the moment of their adoption to determine the provisions which are not constitutional. The advantage of that concept is that it is abstractly clear, and it is considered so important that unconstitutional provisions should be void and invalid by themselves. But application of this concept would result in unexpected outcomes in specific cases based on the unconstitutional laws. For example, in Germany, the decisions recognizing provisions as unconstitutional will result in invalidity of all the rights and conditions. And half of Germany will be without marriages based on that constitutional law. Therefore, in the states using it, they exclude them for the final decision. The alternative for extunct means this we have mentioned already. In Austria, there is an immediate execution of this 140. This is the article supporting the law which applies to the circumstances which happened within the framework of the court jurisdiction, and the court may apply the same decisions to the parallel cases, not the previous but in parallel. It may apply, may not apply, it depends. In some countries, the Constitutional Court may make the decision on its own. In Czech Republic, there is case law on the abstract check of constitutional status of the provision of the law. The judgment of the law is final by itself. In Czech Republic, extunct is acceptable if there is a vertical relationship between the administrative authority and human rights. In some exceptional cases, the Constitutional Court has a reverse effect because in the vertical relationship, the pressure should be given to the protection of the rights against the provision law. My colleague may check. Correct me if the decisions were made during the last 3 years before the decision of the Constitutional Court is made. Maybe your Constitutional Court has made these changes represented by your brilliant chair. Not yet, then it will do it later on. Moldova Constitutional Court struck down the procedural law that precluded the reopening of civil cases by virtue of constitutionality of applicable law. The court indicated that the legislation needs to strike a fair balance between the principles of individual remedy and legal stability by introducing a legislative time limit during which the reopening of civil cases will be allowed for the affected third parties. So it is regulated by the law of the judicial proceedings. If the judge is very active and makes crazy of the parliament, what the parliament may do. They cannot let them cancel their membership or their position. There is a legal way what to do. The court, which is making crazy the parliament to cancel the laws adopted by them, if the judge requests that the parliament may culturally change the law. This is the same situation all over the world. It's not only now. Sometimes ago in Georgia in 2015, the court made us crazy a little bit, and they decided that implement Polish experience with the Constitutional Court. They changed the law to make the constitutional almost disabled, and the court could react to that. The court recognized invalid the application of the foreigners to the Constitutional Court, and they stated that any person can apply to the Constitutional Court. This was not a political question, the constitutionality was on the regulations, on the judgment, and the Parliament said that some decisions should be made because it was a high risk. Sometimes judges took high-risk judgments, and the court said that the barrier is too high according to the constitutional principle, and cancelled that judgment. There was a barrier to ensure the measures of the pre-trial consideration to suspend for a while when they need to review the case. When final result may damage any party, the judge can suspend the judgment until the final result is obtained. I don't know the exact terms for that. They could not cancel that at the Parliament, but they said only 45 days, maybe more, to be valid. The court said that it should not be restricted to 45 days, and that temporary suspension of the legislative act could be admitted. There is a circle for shooting a person. If say it is unconstitutional and the shooting is applied, the court needs more time to think. If you shoot me, there would be no matter if it is acceptable or not. The court may suspend shooting or to use some other measures. The final decision, I would say. That's it, at the end of the publication. When we had no idea that we used the Polish option, that constitutional court should be making the decision which will be valid after publishing in the official magazine of the Ministry of Justice. That was a magazine of the Ministry of Justice. You said it there, and they could not publish for 2-3 weeks, and then they would say somebody, this is the guilty person, and after months this decision could have disappeared somewhere. Then we read on a cultural basis, they canceled this idea, and now the decision comes into effect immediately, and it is published on the website of the Constitutional Court. This is an official announcement of the judgment which belongs to the court. In general, the other questions are not relevant anymore. They were like publication. Thank you very much for a very interesting report and speech. You have touched on the very important concept of the legal consequences, and most of the constitutional courts of European countries and many other countries, they use external concepts because the society is waiting external. But the constitutional control is making the decision. They look at different consequences, maybe not from the legal point of view, but also economic consequences. There was a case, I remember when I was a student of doctorate in Poland, and I was admitted to the meeting, to the discipline of the professor who was a member of the Constitutional Court. I didn't know that. And he said that if a decision for big, you can examine it, and in 1 week we will discuss. And it was about the pension allowances in Poland. The decision was made from the moment of adoption. Those who received smaller pension allowances for the last 10 years, they came smaller pensions, and he asked me about the decision. I was criticizing, I was angry, saying this is not possible, it should not be done like this. And he said, I made that decision, I was the chair at that time, and he explained to me that if a strong decision was made, then it would have irrevocable economic conditions and situations consequent for the country. The difference in the cost should have been taken into account, and otherwise it would have irrevocable effects on the budget. And then when there was a constitutional sitting of the constitutional court, that the decision was made not based on the judicial need for justice and legal determination, but also based on the economic consequences which may occur in the country.
And now I would like to pass the floor to the chairman of the committee under the president of Kazakhstan, Mr. Bashimov Marat Sadetovic. The floor is yours. As a member of the Scientific Consultative Council, thank you very much for giving me the opportunity to make my report in this international roundtable. And this topic was already commented with high professionalism, particularly by the speaker from Georgia. And Georgia was under this jurisdiction starting from 2011, and there was a committee on the human rights, but we didn't have that possibility. So you mentioned the commissioner, and I also passed my regards in 1997, and I made a scientific paper in Georgia. In many cases developed my mind in that regard, and I work in the leading university, and I mentioned that already. The leading law university is having everything, but national law university is having no subject on the constitutional law. Why? And I'm saying about that there should be an objective attitude to the constitutional law, because the double standards and the censoring did not give an opportunity to understand basic of that. I worked in the sphere of theory of constitutional law, and there was Mr. Ipania, and I had the main principles of the Constitution. It gives the opportunity to have the correct attitude that were described by colleagues. So probably the professor like you, he mentioned that in Poland it was exactly like this. There was a high influence, and there was a big bullying. A high criteria was established, and I wanted to explain a bit on different side about the selection criteria, and it's important for constitutional court. 6 years, it's a period of time. Many things can be changed in this situation. So many people are asking, what about the candidates who are not speaking Kazakh, the national language, state language, because this is the language for official, and there are some scientists who are not speaking Kazakh. So if they are talented, which way is it going to work? So yesterday in our conference, a guest from Scotland, the doctors of law, and they had lots of qualifications. And for instance, in UK, they don't pay much attention to the qualifications. The most important there is to be fair. The moral values are most important. So, Anna Kairatov didn't include me into the needed list. I found that there were other questions and had problems. Mr. Sapargaliyev was speaking about the Constitution as the act of the direct action. There were some politicians who made problems for the top management of the country, which led to the situation that we had before. So everything should be based on the principles, and now we would like to have it the principle of direct action. It should work because people voted for that, and constitutionalists voted for that. 30 years I'm the teacher, the professor of this topic, and because of double standards it's very difficult to work in this field. So in many cases, and based on that, the new constitutional court is awaiting its final decision. So the media asked me what are my expectations, taking into account the experience of Georgia, for instance. We also have modernization, transformation, and evolution in this society. That's why the expectations are very high and sometimes too high. Yes, it may be like that, and we were afraid of being overloaded with it. And same thing would be for the constitutional court. They can come over the overloading with the claims. Still, we have many questions that should be solved many years ago. And now, Kazakhstan is having its historical chance. I am 57, and probably you know Marat Abenov, one of the journalists. He told me, you remember in 1986 there was perestroika, and it gave us a chance. And I was a student of the Moscow State University in those days, and we had a second chance to be used. We have a breakthrough in the mind of people. So one eminent expert said, you have a country of well-educated people. You aren't free in your mind, afraid to speak out. And we were traveling with the OSCE representatives in those. We have problems with constitutional court and constitutional legislation. I have been expressing my opinion all the year, and the employees of the Constitutional Court should be made out of professionals, constitutional experts. So I suggested to the Ministry of Justice, let us suggest the candidates who are specialized in the theory of constitutional law. And in case we have some history experts, for instance, in Germany, you should learn perfectly constitutional law. All the legislation is originated from the constitution. I'm not going to deeper details. So with the discussion councils, we had practical workshops, and we had theoretical discussions and study, and there are many problematic issues in constitutional law. And the current changes, in fact, opened the way for us, and we should take that opportunity. We should take this way. We should never go back. We never ask for anything special. When you say the truth, people don't like you. We are having new Kazakhstan. We're trying to change our mentality, legal mentality. There is a new generation who started a book and created the universe as a creature. So they have different approaches. And I would like to discuss materials that took place in the sphere of human rights and freedoms protection, and as well as other changes that always I have been telling about that all the time. Also, I was speaking about Rahat Aliyev, and I wrote an article about him. And also, Rahat Aliyev said we should establish monarchy. In 2007, there was an event, so I called him. So I was informed that he is a criminal. I was advised not to work with him. So, another republic different from monarchy. And actually there should be monarchy. Some people are trying to make fortune on me. Always keep distance, my point of view. I know many experts in different areas, and let me wish you to have good health, wealth, peace, and fruitful work to the external classes, to support people, places, and as far as I understand, as it was said, while in Parliament you should work. Like now, there is a megapole, and I suppose how much I care, everything is in Constitution. So we checked what was written, and then we started to check for corruption. And there was Nurlan Yelimbetov. There were questions. In 1937, such a person would be shot and killed. And I graduated from the Moscow State University, and I'm sure that constitutional law will be developed here, and our president is his efforts to develop it, and it will be great. My report is born in English, Russian, and Kazakh. Thank you very much. Now I would like to pass the floor to the head of the Caspian University.
Thank you, dear participants of the conference. It is always difficult and easy to speak everything you have drafted for yourself was already mentioned. Not to repeat what was said, I'd like to mention that the participants of the conference, they think the same direction, I would say, and the problems we expect with the establishment of the Constitutional Court, they are typical for the others in Georgia, in many and other countries. They are repeated. And the experience is absolutely useful for us. At least we would potentially use the experience to provide some provisions. I would like to start with the question of efficiency. The decision of the Constitutional Court is a condition for the system to be expected with provisions to eliminate from the judicial system the regulations which do not comply with the Constitution. The activity in this respect of any government authority, and first of all the constitutional control, should be efficient, not from the point of view of some personal administrative elite, intra-departmental interests, but I think from the view of being useful to society, brings results. The goals we have set within the activity of the Constitutional Court, it is protection and defense of the rights and freedoms of the citizens. To some extent, this is generation, formation of the vectors of the legal policy. They should coincide the activity of the Constitutional Court, the results of activity, and the goals we are setting nowadays. Draft of the constitutional law and the Constitutional Court, they should coincide for sure. Otherwise, there is no need for supporting, maintaining this institution at the expense of the people's money. My colleagues have emphasized that as well. And the formula is very easy: efficiency of the activity of the authorities and efficiency of the law, the goals and the results of the authorities should coincide. What is influenced by the what is the efficiency influenced by the level of corruption, the level of independence of the government authorities, the level of independence and transparency of the government control people who will determine the positions and vectors of the legal policy of Kazakhstan and the approach of those specialists. At formation of the Constitutional Court, it is important to take into account strict requirements and criteria. The criteria which are specified in terms of age, education, experience. We have millions of people like this in Kazakhstan, and all of them correspond to this criteria. But still, we need more high-quality criteria with characteristic to balance somehow the Constitutional Court administration. The two different people in terms of age, even. Firstly, secondly, they should be the conservative and liberal mode of thinking. The legal position, the final decisions of the Constitutional Court would be more socially expected and balanced. In this respect, maybe there is a reason before we adopt the law that the subjects of appointment of the judges for the Constitutional Court, the President, the Chairman of the Majlis and Senate, it was the same as at the formation of the Constitutional Council. They could suggest not only one candidate, but sort of alternative candidates, but based on the decision to be able to understand the level of preparedness, the theoretical knowledge level of different candidates. Otherwise, if we have a different approach, then we will have about 1 million people complying with the criteria prescribed nowadays in institutional law. This is one thing. Therefore, what I mean, the final influence of the executive functions when the decision itself must be more justified and argumented and reasoned. It will be connected with the administration of the Constitutional Court again. As Mr. said in his point, what is inside of a bottle, it goes out from the bottle. You know all this comparison. So what is the composition? This will determine the final decisions. If it will be convincing, if it is reasoned and justified, then the execution, there will be less questions and challenges for the prosecutor's office bodies and other executive bodies. And when the judgment is not justified, how it can be executed? Maybe I have never been an official and I don't understand something, but if it is a doubtful decision from the point of view of the content and argumentation and grounds, is there any mechanisms for responsibility of those who make such a decision? Such decisions are met sometimes in the practice. We will not go into details, but I think it is important for the executive function to be at a high level. It is necessary that the decision itself complies with the specific criteria. Indeed, the law says that it should be justified, objective, multilateral, etc., but also always with the fact there is some dependence between the judges and the Constitutional Council upon some circumstances. Therefore, the Constitutional Court should be truly independent and to make unbiased, objective decisions, not to satisfy somebody's interest, but just to comply with the rules of the Constitution. The second problem, in my opinion, which would be able to influence the executive function for the execution of the decision, is connected with the status of the Constitutional Court. Until now, I do not understand why, when they made the amendments, although we discussed that, the discussion in the Constitution itself, they did not determine the status of the constitutional results. The question is that there will be 11 judges, what they will do, but what the Constitutional Court will look like. We have a status of the parliament, we have a status of the president, there is a status of government, but there is no status for the Constitutional Court determined, although they should have written that this is the supreme body of the constitutional control, ensuring the rule of constitution. There is no need to create something new. There are existing terms in this respect. Another thing which is not sufficiently regulated, this is about the constitutional complaint which has been mentioned today already. I do not really understand about the foreign citizens and people without citizenship, if they can apply the constitutional court. I think 70 or 71 of the Constitution says that the Constitutional Court considers the complaints and appeals of the citizens, but it is not said if it is citizens of the Republic of Kazakhstan. Does this mean that foreigners may apply to the Constitutional Court? This legislation may be interpreted in connection with other regulations of the Constitution describing the human rights and freedoms, when we say that the person is the supreme value, then they can apply. But in the constitutional draft law, this issue is not regulated in any way. I think this should be determined somehow. And the thing I'd like to mention here is that this execution of decision, sometimes it may be an excellent, perfect, justified decision, 10 pages of text written. At the same time, we know what happens in practice. What if we establish responsibility of the officials to whom the decision is addressed, the decision of the Constitutional Court, to establish responsibility, disciplinary, administrative, penally, for example? Maybe then they all will execute the decisions. This is my proposal. And not to have overloading of cases, what we are afraid of at the initial stage. At this remaining time, before the Constitutional Court started to operate, maybe there is a reason for the Constitutional Council, together with the Ministry of Justice and interested parties, to make a sort of webinars or launch sort of social networks and videos explaining what constitutional complaint is, who can appeal with such a complaint, in which cases, what could be the consequences, and so on, the question of duties, and so on. It could be a short video providing the idea. On the 1st of January, after the 1st of January, the people will run to the Constitutional Court because they have so many problems in their personal relations, in the taxation laws, immigration laws, and so on and so forth. All these questions could reduce this kind of risk, and this could be done by the way of such of awareness raising. And it would be good, if possible or not, if in the constitutional law, the Constitutional Court, in the section execution of the decision, it is mentioned directly that on the basis of the decision of the Constitutional Court, the President of the Republic of Kazakhstan, as a guarantor of the Constitution, will issue an order instructing the Parliament within this period of time, government within this period of time, archives and so on, bring in compliance with the legislation the respective persons in accordance with the decision of the Constitutional Court. I think a huge role may be played by the President of the Republic of Kazakhstan in execution of the decision. Thank you very much for your proposals and ideas, dear Mr. Raif. I think we will have relevant videos and materials on how to apply to the Constitutional Court. I'm sure in the nearest future, after the 1st of January, there will be a lot of complaints coming to the Constitutional Court, which will work in the future. In the beginning, it will be difficult for the Constitutional Court to work with all these claims and cases. Of course, we have heard all the reports of our session. Now we move to the discussion. You can ask questions to the speakers in Nur-Sultan, in Almaty. You're welcome. I have a question. Can you hear me, Miras Muharovich? Yes, we can hear you. I'm happy. You please ask your question. My question is about the constitutional. It is connected with the circumstances that the members of the Constitutional Council not like this. Maybe I am like an employee from the Czech story, but I know that problem many times. It is a problem connected with the criminal responsibility for the damaging for maiming, which based on the report of academician was recognized as unconstitutional self-injury based on the judgment of the Constitutional Council in 2007. It was recognized as unconstitutional, but in the Criminal Code of 2014, which was the article number 428, part 3, there is a criminal responsibility for this harm. They have retorted, so to say. And based on that article, Semipalatin's court has accused 3 persons convicted attracted to the responsibility based on Article 423. Mr. Akhmetov, writing complaints and appeals many times, what I want to say is that until now this regulation has been cancelled. The Constitutional Court solved the problem of responsibility for non-fulfillment of regulatory acts of the Constitutional Court. As Ali Pasha asked a question of establishing or prescribing the responsibility for ignoring, neglect, non-execution of the regulatory act and other resolutions of the Constitutional Court. How this question is going to be solved in the future in the new constitutional law? This is my question. To whom do you ask this question? To the constitutional experts, people who develop the draft constitutional law on the Constitutional Court. Viktor Alexandrovich is here, a member of the Constitutional Council, so the floor is yours. Thank you very much, Ramazan Yakovich. You are a member of the Scientific Consultative Council at the Constitutional Council. We could have discussed it there. What could I say on the first question? It is not my sphere of the criminal law. However, remember that decision, by the way, was made by the Constitutional Council on the appeal of the Kapchigai City Court. It really raised a lot of problems, and on its initiative, a number of decisions was made. How this regulation was included into the new criminal code, I don't know this, but I think there should be some structures which are dealing with the creation of laws. It could be Ministry of Justice or structures of the Parliament or administration of the President, check and control that this never happens again. As for your second question,
I don't think that we should go too much to the legal liability for the officials. In my understanding, if there is a decision from the Constitutional Court and it's not executed and it is registered in the appeal to the Constitutional Council for some official or in the decision of the Constitutional Council, then, according to that information, there should be responsible people who elected such official. They should take a decision, either disciplinary liability up to firing him or her. So there should be particular measures. Just yesterday in the Eurasian committee named after Knife, I remembered one case when we visited France and we met a commissioner of the French Republic and we asked him, could you please tell us? So you provide recommendations and you send it against particular officials or to some official, and he is not executing that. He was supposed he may not implement that. And he answered that he would be punished, and he understood the question of mine just after third time I repeated, and finally he responded that in case the official is not executing the recommendations, then we would contact mass media and he would have all the problems possible. So this is the way I think it should be. So the Constitutional Council is quite new. So I know the institutions of the civil society are not well developed yet, those who could be involved. So I think we would not be able to change the situation much. But reinforcing the liability, I don't think it's the best way. And one more question. It's not question, it's an addition. The decision of the Constitutional Court, its execution is working much better now. And once in a year, the Council on the Legal Policy is implementing the decisions of the Constitutional Council. And in case of problems, they decide quite quickly. Does not mean that there is 100% of the implementation, and the latest example is giving the idea. Yes, there are cases like that, but we collaborate with other state bodies on that. Thank you very much. Georgi Mugzarovich wanted to comment. Yes, this idea will go great. I don't know if you have a special committee to draft the law on the Constitutional Court. It would be good to have a working group together with the international and local experts, so to approach the draft from different sides. I have read one draft of the law, but I do not comment it much. I marked two. One of the examples, as it was mentioned before by one of our colleagues, the appointment or the election. This is a serious question. For instance, despite the war in Ukraine, together with experts, there is elaboration of the law, supposing that there will be an council having representatives from universities, international organizations, and different branches of authorities. They would prepare candidates for parliament, for the judicial power. They would suggest 2-3 candidates for one position. So the preparation and selection would be basing on the professional experience. Other countries will participate well. So some experts should be retired with a high pension allowance. So they should not be taken as candidates. And probably you have seen in American system what happens to candidates in Senate. You have to listen to them whole day, what happened during 30 years of his work, or probably he was chasing some lady 30 years ago in his youth. So they do it transparently to take into consideration all the moral values and fair law. And Still, it's up to the parliament, to the president, to choose the best from this. There are other moments in the draft of the law, and it's subject to improve in the future, and if needed, we can involve representatives from neighboring countries, from international organizations. Good day, dear Sergey Ivanovich. We are glad to see you. First of all, let me thank the organizers for arranging this forum. Lots of interesting things. I'm with you from the very beginning till the very end of the round table. I would like to comment the decision of the city court decision. I'm very much sorry, but the connection doesn't work. We cannot hear the speaker at all. He has very poor internet. So I had a discussion with those who elaborated the draft of the law, and I got an answer. And I got the explanation that according to their opinion, the content is different completely. I'm not going to give more details. And secondly, it was told that the Constitutional Council in new edition does not consider that article. And I was asked to express my opinion. The problem was quite serious. Seems to me that Mr. Ramazan perceived that correctly. George Papuashvili and other members and ex-members of the Venetia Committee, probably they know that many times the Venetia Committee considered issues. Now I'm citing it the way it was announced during the meetings of the Venetia Committee, the issue on the relapse of the legislation means when the parliament of a country is duplicating the decisions that were before taken and proved by the constitutional control bodies non-constitutional, and sometimes introducing the changes, sometimes without introducing the changes into the new law. Pity to say, there was no unified opinion. This is quite a serious issue, and we should think twice before adopting in the Parliament the draft law on the Constitutional Council. Probably we should think about the impediments to replicate the provisions that would be considered as non-constitutional. Probably we think the way Constitutional Court may react, not only in the addresses once a year, but also by different acts. Constitutional Court, like the Constitutional Current Council, cannot consider the cases by their own initiatives. The problem is not only for Kazakhstan. This is At many times while considering and also during the Venetian Committee in Europe. Thank you very much for the organizers and for inviting. Thank you very much for your comment, dear colleagues, dear participants of the round table. If you have any questions or comments, you are welcome. No questions, no comments, so let us summarize the results of our round table. Dear participants, we have been discussing a very important topic that is the main one in the agenda over the world. The evolution of constitutional control in the context of societal and state transformation is important. There were amendments into the Constitution. We were voting during the Republican referendum, and everybody was waiting for adoption of the law, because the Constitutional Court should start to work in Kazakhstan, especially under the terms and conditions of transformation, and on the 1st of September there will be an address from the President of Kazakhstan, Mr. Tokayev, and that's why the topic of today is not chosen by chance. It was formulated like that because the constitutional control is not possible without state transformation. That's why today we have our distinguished guests from the Venetian Committee, from the South Republic, the ex-chairman of constitutional courts of Georgia, Croatia, Moldova, and many other countries. Also today we had an ombudsman, the Commission on Human Rights Protection in the regions, and also we had experts and scientists in this sphere. We had a lively discussion, fruitful discussion, to discuss different topics and issues. There were practitioners and scientists in the sphere of the constitutional law who are dealing with this topic daily. And the conference of International Roundtable of today, we had an opportunity to broadcast for the teachers, professors and students, and I'm sure it was useful for everybody. And upon the results of this event, we will publish the materials with the reports from our today's speakers in order to continue this discussion. And in case there were issues that were not discussed today, actually there was no task to respond to all the questions. So this discussion, I'm sure, will be continued in the other fields and platforms. Thank you very much for your time, for participating in our event, and to be prepared in details to what's going on in Kazakhstan, and to be prepared about the reform that is in the agenda of today's Kazakhstan. Thank you very much for participating in the round table. Let me wish you good health, wealth, much achievements, and the fruitful work, and to go through the stress test. All that is done to the favor of the people of Kazakhstan. Thank you very much, Miras Sultanovich. Let me wish you to have a good Constitution Day. Guests, could you please come to the bar and have a good photo? We will fly to you from online.